operation services. I'm asking for amendment.
That's fine.
The new charge in which the new post in which he created, not the charge, as he offered.
You just stop the look. It's just your argument, so it's not a charge.
It's not a charge. It's a post.
Yeah.
We're typing it.
Okay, fine.
As he offered a fixed term of contract for duration of 5 years at the salary package of 1.5 million per annum. It is alleged that this position was never advertised internally or externally as required by the SABC recruitment selection policy.
Okay, just stop there. I don't want to interrupt you all the time.
Yes.
But you are now, where in the evidence was this before me that you are now submitting here?
It is a charge.
Is the charge?
Yes.
And the allegations in the charge?
Yes.
Is that what you are saying here?
Yes.
All right.
These are the charges. These are the allegations on the charge sheet.
Okay, so you're dealing with the charges?
Yeah, the charges.
Okay.
I will come to the evaluation of evidence.
Okay, thank you.
Thank you, Chair. It is further alleged that no interviews process were conducted in appointing Ms. Mutsweng, not Mrs. Mutsweng, to the latter position. It is further alleged that he appointed Ms. Mutsweng to the latter position without having complied with the SABC delegation authority framework. The above selection required that the appointment to the newly created position must be approved by the Executive Committee. It was never approved to the latter committee. His action in the above regard contravening the provision of the selection of the recruitment policies constitutes gross misconduct. Abuse of position is count charge number 3. In that it is alleged that during his tenure as the COO, he unfairly dismissed senior staff members in the SABC for differing in opinion with him. It is alleged that he directly initiated the dismissal or termination of employment of the following individual: Bernard Goma, Hosea Gianni, Solotulo, Monvenyani Dikoko, Ms. Mapula Mbalati, Nzwaki Ramaphosa. Employer's case. The employer presented its case through testimonies of 5 witnesses, whom were the following. The first witness was Jabulani Mabasa. The witness testified that...
Whoa. At this point in time, you're going to now summarize here what
Yes.
the witnesses in camera have said.
Oh, okay.
I've not made my final ruling on that. So perhaps this is the appropriate time that you tell me what your approach on that is, because you cannot just start arguing here in public what they testified when you asked for it to be in camera. You understand what I'm saying?
Yes. The ruling should be...
Are you abandoning the in camera then?
No. The ruling should be that...
Because I have to make a ruling on that stuff.
Yes. I'm not abandoning it.
Well, you are starting to motivate in public what they have testified.
No, I haven't started. I will leave it.
Sorry, just a second. Yes, Mr.
Chair, I also didn't want to unduly, inconvenience my colleague because we are at the argument stage. But that's precisely the point. I was just about to interject and find whether or not is he deciding now to lift that veil. Because obviously he is now about to start dealing with the evaluation of evidence that was obtained in camera, and we are now in the full glare of the camera. It doesn't bother me at all because you are the one who asked for it to be in camera. So, Chair, may I suggest, so that we are not unfair on him, let perhaps the Chair give us a ruling on that issue. Because when in the fullness of time, when my turn comes, I was going to bring an application to you on exactly the same point.
All right. Mr. Palani, I understand that you are just referring to your initial argument and that perhaps you want to deal with detail later when you evaluate the evidence. But I'm in a difficult position now because you have applied and I provisionally allowed you to lead your evidence in camera, and that I would like to make my ruling on whether it is lifted or not, depending on what the evidence was. But I think for the purposes of yourself arguing on those, you must tell me that you want to argue those witnesses in camera still, or do you want that argument now to be cited before you argue?
It should be argued in camera because they've indicated that they are still in place of SABC and the ruling was made. I think it will be appropriate for it to be in camera.
You see, the problem is then I have to hear your argument in camera and then out of camera, and that's inconvenient, you understand?
But
so I'm going to make the ruling now that I don't want to catch you off guard now.
Yes.
I think best is, for purposes of convenience of everybody, perhaps you must now request me or address me on whether the evidence that you let in camera, whether that should be finalized in your favor or not. Because that makes it easy for everyone to either argue whatever who said and cross-argue and whatever. Because perhaps it might be that you want to refer me to a witness who argued not in camera, who corroborates someone in camera. You understand what I'm saying? So this is better for me. I think I'm going to make the ruling now that perhaps if you are ready, why I should make a final ruling in your favor of the witnesses who testified in camera or not. Are you ready to do that?
I would submit that I'm not going to. I may leave out the testimony of the witnesses that testified in camera.
But I want to hear you on that, what you think of them, and what you want me to find as a fact or not, you understand? I have to first make a factual finding on the evidence and then evaluate in terms of what is alleged against Mr. Motsone and whether he's contravened those charges or not. I want you to address me on all the evidence in front of me, you see.
What I suggest maybe it could be is that we may not refer names. Let's say that maybe witness number 1, 2, and 3.
No, sir. I'm not going to do that. It's either in camera or not, and I want now you to address me why I should make a final ruling in your favor or not. Because then it's easy to argue after whether it's in camera or not, you understand?
Yes. Especially the witnesses are the employees of the SABC. They've demanded protection. They didn't want their evidence to be heard in public when they were testifying for strange reasons that for the reasons that they will be prejudiced. So I believe that to now deal with their evidence in the media and in front of the camera will defeat the purpose on which they were testifying.
Correct.
Yes. So
that's why I want now you to address me on whether it should still be ruled in camera finally or not.
It should be ruled in camera finally.
Yes, but you must address me why. Why? You're asking me, I understand you're asking me that, but you should convince me why. Because we've heard the evidence now, and you must now argue why, in terms of the prerequisites of evidence in camera, why that should be a final ruling now. That's what you want, so tell me why. I'm referring to what we've heard.
Yes. I've already told you, Chair, that the issue is if this evidence is to be on the media and in camera, the employees will be prejudiced, and the protection they sought during the application will no longer be there, because now everything that they said now is going to be on the public.
Yes, correct. Initially, you indicated that they would be prejudiced.
Yes.
And I was leaning over to you to assist you that I provisionally allow that.
Yes.
And because of the interest of justice, I wanted to hear them, and I want to know from you whether those witnesses confirmed what you had addressed to me initially, if it is a fact that they should stay in camera or not. You understand where I'm going? You understand what I'm saying?
It is a fact. Their evidence should remain in.
Yes, but where was the evidence that they were going to be prejudiced when they testified? I never heard anything like that, did I? You never led them on that. Why should I rule that it still stays in camera? You understand? Perhaps I should adjourn a bit, that you get proper instructions. And after you've addressed me, because remember, you applied that I should hear the evidence in camera on the basis that they were going to be prejudiced.
Yes, Chair.
Correct. And
yes.
I was on the verge of not allowing you that, but in the interest of justice, I did. And I said provisionally my ruling was that it was in camera, and you should convince me during this evidence why they should why there should be a final ruling that it does, with the prerequisites of having evidence in camera, why it should be accepted. You understand that?
Just to indicate the prejudice, I will go to the witness of number.
No. I think I said I'll adjourn first, that you get proper instructions. Sorry, Mr. Majabu. You want to reply quickly?
Indeed, Chair.
Yes?
You know, to be frank, even, and obviously if the Chair makes that ruling, I'll abide by it, whether we should adjourn or not. But I'm saying, Chair, with respect, this is bordering on being ridiculous now. The application that you granted in favor of the employer, as brought by my colleague, was simply anchored on the following basis. Firstly, he made all of us believe that the only request he was making was with specific reference to the cameras. You ruled, Chair, that the cameras must be shut off. And I remember the two cameras that were to my left even had to face that window. As we are about to start, and the record will bear me out, he then brought another application to say, no, I want the entire media out. You then said, Chair, now, Mr. Palani, you are bringing a different application on a different basis that supported my earlier ruling. Let us re-adjudicate this matter. The matter stood down. He took instructions, came back, and he said, if they testify in the presence of the media, then they would rather not testify, holding us to ransom. You nevertheless proceeded again and granted a ruling in their favor, and the entire media houses were cleared. I even made the point to say, I fail to see on what rational basis can a non-invasive microphone hinder a person from testifying. The central issue here was their ability to testify at the time. They have testified, they have been cross-examined quite thoroughly by myself, they were re-examined by my colleague. There cannot be any prejudice. We are referring to what has happened. There is nothing that warrants any taking of instructions because it is there. He's given me his heads of argument or submissions referring to those specific people. Now, how am I going to argue against those by referring to them as witness A, witness B? It cannot be. The prejudice that he said was if the cameras are glaring at them or if the microphones are there, it will hinder them in testifying at the time. That prejudice has now been averted in that they testified in the absence of the media. There can therefore not be any rational basis on why. As a matter of fact, Chair, if you had not pointed that out to my colleague, he was obliviously going to go on. He was about to say he mentioned a witness whose name I'm not going to mention. And he was about to make mention of what they testified. Now, where was that prejudice before you stopped him? It is honestly, and I say this with greatest of respect to my colleague, it is now bordering on being ridiculous. I'm opposed to any further standing down of this matter. We accommodated all of us. We started late.
Thank you, Mr. Majabu. Any reply on that, Mr. Palani?
My reply will be to go to your earlier suggestion, maybe to take instruction from.
Yes, but you must understand, I've been very lenient on you.
Yes.
And I understand the situation because on Monday morning only you got instructions. But we should sort, at this point in time, get our acts now together at some sort, you understand?
I agree with you.
But I do not want to prejudice you. But you must please understand that I cannot stand down all the time. If you are not ready to argue, then you must say so. But I understood you to be ready, and now I see you are referring to in-camera evidence in the open court. And my ruling is now that you should address me on that first, or not. Or are you abandoning or not? So that might be a bit ambushing on you because I see you didn't understand this properly. But if you want instructions, I'm going to adjourn for 5 minutes, and I'm not going to wait for you again. You must please be on time now. Are you clear on that, sir?
I'm
I will adjourn for 5 minutes, and then we start. And
As
then
the
you
chair
must argue.
pleases. As the chair pleases.
No. Where is it? Okay. 0.
That's what I'm saying. It doesn't matter. Evidence is there. It's argument. We are trying to persuade. Either we persuade him or we don't.
Remember, the emphasis was on the witnesses not being free.
At the time, now they've... No, you know what, bro?
Oh, no.
It is honestly.
Mr. Majabu, we are pleading with you. No, it's fine.
It's my time.
No,
No,
Mr. Majabu.
no. You can carry it live and we record it. It's honestly. 5 minutes, start, stop. No. These people went to the public protector privately. What they said was publicized. This man is publicized every day. Now we must forget about this prejudice.
Yo.
No, it's really. Okay.
This is better than Judge Judy, ne? Hey, you can't quote me. I'll sue you.
Cameras are rolling.
I'll sue you.
We are live. Go ahead and send.
Never.
So, all of a sudden, I need to be meeting my camera. The man who has always been in front of the camera. So if you check that, I want them to acquitted. They must still face me.
This 5 minutes.
Yeah.
See, not enough.
Yeah.
Oh, okay. Is it? But then we had a transfer of the
The new chief in town.
I am
He's unemployed. What did I do?
Why do you say he's unemployed? He's no longer with the...
He's unemployed. He's unemployed.
When did he leave?
He wasn't drinking last night. I don't know whether he was fired or he resigned.
Why don't you know?
I didn't. But they were frustrated.
Who was frustrating?
I've been outside.
They was frustrating Ricky. I thought he was the biggest Indian in town.
He was the biggest Indian in town. He was fooling people. He was fooling people.
He was fooling people.
I was fooling people. That's it. And no powers.
As I said, I thought he was the guy in charge.
Don't talk about success. Because as soon as you talk about success, factions start forming around the team. That's how it works.
Hey.
He was so frustrated. He's no longer this. No, he's no longer this. He's been shifting both feet. That's why you see him doing leg crosses and pushing on this. Are they getting the text of the things nice? Why did they make people that long?
And I can assure you, if Mtakwana Sam stop, Nanos will lapel without seeing anything wrong with it. I don't know. We are sitting here, you are lying. I honestly don't know.
Thank you. We resume. Thank you, Mr. Polani.
My instructions are as follows: that since the application was brought in order to protect the identity of witnesses, the application to lead their evidence should be in camera. I mean, it should be in camera, yes. However, I will indicate that the discretion to grant that application rests with the chairman, having heard the evidence so presented.
Thank you.
Yes.
Is that all?
Yes.
Chair, firstly, the latter statement that my colleague makes is obvious. You are the trier of fact, the decision ultimately is yours. When we stood down, you afforded my colleague a collegial opportunity to take instructions. He comes back, he says, the earlier application was brought on the basis of protecting the identity of witnesses. That is not true. I invite him to search the record.
No. Mr. Majava, I have to ask.
Please don't interrupt when someone's arguing.
Yes.
I'll give you your opportunity to reply.
Okay.
Right?
No, I will reply definitely.
Okay.
In fact, I never interrupted my colleague when he spoke. All I am saying, and we've got a recording here, we can play it back. I am saying now on resumption, he spoke about the identity of the witnesses. And I am saying, when he brought that ill application, Chair, I don't want to go backwards and forwards, you will rule. The point of the matter is, nothing was said about the identity of the witness. So what was said was that the presence of the camera or the presence of all forms of media would hamper the witness's ability to testify freely and voluntarily, and also because they are still currently in the employ of the SABC. That was the basis on which that application was mounted. Now, pursuant to you affording my colleague an opportunity to take proper instructions on what he intends to do about that which he had started doing before you stopped him, by the way, he now comes and talks about the identity of the witnesses. Let me deal with the identity of the witnesses anyway. The fact of the matter is, the identity of the witnesses becomes irrelevant because it is going to become known because he himself has disclosed that in the submissions. And in my dealing with his submissions, I'm not going to pull back any punches. I am going to say this particular witness had this to say. Mr. Chairman, believe it or don't believe it for the following reasons. So it cannot be that the identity will remain a secret forever. You know, Mr. Chairman, what irks me about this whole thing is that when it comes to my client, his identity, his rights, his privacy, nobody cares about it. The only protection that we must worry about is that of the very same people that brought us here, namely the employer. These are the employer's witnesses who came to testify in support of the charges that the employer preferred against my client. But having said that, Chair, the test on which my colleague must attempt to persuade you is one of prejudice. And prejudice has got absolutely zero to do with identity. Unless if he says they let evidence of such a nature that if the identity is made known, they will get killed or they can be threatened or something of the sort. That has not been placed before you. He's asking for an indulgence from you, but he's not giving you basis on which your exercise of discretion is going to be mounted. There is absolutely nothing that has been put to you. In fact, Chair, I'm going to invite you for the sake of progress to make your ruling now so that we go on with this show. It is really, really becoming ridiculous to the exponential degrees, Chair. And I say this in seriousness.
Mr. Majagu, with regards to the prerequisites of having evidence in camera, would you kindly address me?
Yes. The first one was always to avert any potential prejudice that the giver of evidence may suffer, whether real or perceived. But it must be substantiated on objective facts that are determinable as indicative of the fact that it would not be in the interest of justice to rule differently. But
I'm actually referring to what we've heard.
There is absolutely nothing because, Mr. Chairman, you and I and my learned colleague were there when they testified. The first witness, whom I shall not name, gave evidence of a general nature. So did the second witness. The third witness was one that came close to pointing a finger at my client. But even so, it was nothing that could be said to be personal or wow. And in fact, Chair, the following day, when we had the second category of the three witnesses that were to testify, we started off with the cameras present. He brought a similar application to say the witnesses are not comfortable. And a question was put to him by yourself, rightly so, to say, on what basis? Because these witnesses are non-SABC employees. He insisted to say they are not comfortable.
Sensitive is the word.
Sensitive is the word that he used. They are about to give us sensitive information. This is a kind of sensationalization that has besieged this particular matter all along. You ruled that the cameras should not face those witnesses or show the face of the witnesses, but the non-invasive microphones must stay. We proceeded on that basis, and the rationale distinction between the two rulings that you made was because in the previous set of witnesses, it was expressly stated that because they are still in the current employ, the witnesses that testified after that were not in the current employ. Now, the whole question of prejudice, the high watermark actually of that question of prejudice was simply because they are currently in the employment of the SABC. and I'm not putting words in his mouth, but by extension of logic, one can surmise that for fear of reprisals. But we know the evidence that they led, there was absolutely nothing earth-shattering. So I'm saying on that basis, Chair, again, even in spite of having offered my colleague an extended opportunity, he has placed 0 before you. That would even begin to enable you to exercise your discretion again in favor towards that. Whatever they have said has come and gone. It does not matter what I may think of their evidence. Ultimately, what my colleague and I should attempt to do is to persuade you why, in my case, my client should be found not guilty, and I'm going to do that. He must similarly tell you why he should be found guilty, but the ultimate decision rests with you, Chair. And we are wasting crucial time on a very simple matter. If there was indeed serious prejudice of the sort that warranted instructions being taken, why is it that my colleague went so far as mentioning the first witness by his name? If you had not intervened, Mr. Chair, I dare say he was going to proceed. And I deliberately allowed him to do that because I wanted to deal with those witnesses. But be that as it may, Chair, I've made my point. This is a complete waste of time.
Thank you, Mr. Majabu. Any reply, Mr.
Yeah, in reply to my colleagues' comments, I would definitely argue that my colleague does not work for the SABC. He doesn't know what is inside the SABC. If we talk about what evidence, who is who in the SABC, and if my client feel like if they came here to give whatever evidence they have given, they will be prejudiced, nobody can say how and why, because we are not the employees of the SABC. We don't know the structure of the SABC, who is at the top position, what is happening. We do not know. I believe it will be, they've got families, if they feel like they will be prejudiced, let us not press on them.
Is that your reply?
It is my reply, and to say that there is no prejudice as if we know what is in the SABC, I think it is unfortunate. If that is the ruling, I don't know, but it is unfortunate to speak on their behalf and say they won't suffer prejudice. If they suffer it, what is the remedy then?
You see, Mr. Palani, I did not have the privilege of seeing your written arguments before the time. I followed them as you started reading. And I would have expected that you would have addressed me on this first, before you started with your arguments, which I thought was following. Because obviously it's most important when you want to deal with the evidence, that whether they should still be in camera or not, you understand. But it's almost impossible to address all the relevant witnesses if there's not a ruling on that. You understand?
Yes, yes.
So is there anything else you'd like to add with what I've just told you?
No, nothing further.
You, Mr. Majabu?
Chair, let's go on with the show. I leave it in your capable hands.
Thank you very much. My ruling is the following. I will deal with the reasons during my ruling, my main ruling in the end of this matter. But with regards to the provisional order of the witnesses in camera, I lift that ruling. It is now open.
As the Chair pleases.
As the Chair pleases.
Thank you. Now you proceed.
Thank you very much, Chair.
You wanted to start at 3.1.
3.1, yes.
The testimony of Mr. Jabu Lani Mabasu, the first witness in camera.
Yes.
Right.
The witness testified that he is in the employ of SABC as a group executive of human resource. His duties involve developing a people strategy for the organization, overseeing human resource, recruitment and termination. He testified about the policy. Hereby it is the policy that was handed in and is an annexure to the proceedings.
Annexure T.
Yes.
B for Delta, eh?
Yes, annexure T. He testified that in his opinion, for a person to be appointed as a trainee general should have PhD or at least a graduate, and he added the weight, I do not know. he perused the employee file and did not see a matric certificate. Testimony of Ms. Lorraine Francois. She is an employee of SABC. She is employed by the SABC in 2011 as a Chief Audit Executive. Her duties include providing assurance to the SABC to the strategic, all business procedures and regulations, and forensic matters. He testified that she or her office will investigate a person on anonymous complaint, that the SABC has until corruption policy marked here Exhibit 2. She read paragraph 6 on page 7. She testified that in terms of the SABC policy, she can investigate an anonymous complaint. That is the policy of the SABC to do so. Testimony of Mr. Munjanyani Dipogo. He is employed by the SABC. He joined the SABC in 1993 and left in 1993. He left and worked for Media 24 and came back to the SABC in 2006. The reason he left the SABC, he wanted to venture into a business and end up in business. He knew Mr. Mutseneng. He was working at Bloemfontein SABC, whereas Mr. Dipugo was working at SABC in Johannesburg. He was dismissed by SABC in 2009 by Filmolive. Testimony of Bernard Goma. He was employed by SABC in 1981. He read the employment application form ended in as Exhibit E. Exhibit E, which state the following. On page 1 of the application form under heading Employment Education, it indicates highest standard passed as standard 10 and subject 5 subject passed. On the same page, it was written with a marker, Outstanding Metric Certificate 3/95. On the second page of the said form, there was no signature of the employee. He testified that in his opinion, minimum subject to a metric certificate is 6 to 7 subjects. In fact, I must say that he added that to pass it with 5 subjects, you must be a genius. He was instructed to investigate the employee. He then pursued the employee's file and he perused the employee file and he did not see or find the employer metric certificate. The charge of misconduct was preferred against Mr. Mutweneng. The disciplinary hearing was aborted. He suffered abuse of power by Mr. Mutweneng. There was an issue of leasing of Mercedes-Benz. Before he can even be notified of the disciplinary proceeding against him, Mr. Mutweneng told him he was going to dismiss him. That is what he said. Later, Mr. Fulmelefe appeared on SABC and he said that he had fingered a suspect. He received a telephone call from a messenger when he was off duty. He was told to collect a letter. He arranged with the messenger to meet in Pretoria. He was given an envelope, and inside the envelope there was notice of disciplinary hearing. After that, he resigned and consulted with his attorneys. Later on, he went to the CCMA to lodge a claim of constructive dismissal. The matter was settled. He participated in drafting of audit report and confirmed that the content hereof. The said audit report was handed in as an exhibit. Around 2013, he was interviewed by public protector.
That's F.
Yes, as the chairperson.
We have to deal with F also, but we'll get to that.
Yes.
That is 3.4.16, no?
Yes.
Okay.
Around 2013, he was interviewed by a public protector, and he told her about his dismissal, and Mr. Mutsoening was requested by the prosecutor to apologize to him. Then the evidence of Mr. Paul Tati was led. He testified that he was employed by the SABC as human resource consultant at the Free State, Bloemfontein, in 1 March 1996. He was responsible for human resource support and services. He had good relationship with Mr. Mutsoening. Mariswanopul, the previous human resource, instructed him to get Mr. Mutsoening's outstanding matric certificate. He was told by Mariswanopul that a year has lapsed since Ms. Elena Bota requested the matric certificate from Mr. Mutsoening. He spoke to Mr. Mutsoening regarding the matric certificate. He assured him that he got a certificate and he will provide him with the same following week. Mr. Mutsoening came back the following week and he told Mr. Tati that he does not have a matric certificate. He has one subject outstanding and he undertook to obtain the matric certificate by October 1996. He wrote the letter to Mr. Mutsoening requesting a copy of matric certificate. The letter was annexed as an exhibit. He testified that around 2000 he was transferred to another division in Johannesburg, SABC. He waited for Mr. Mutsoening's matric certificate from 1996 to 2000, and that is 5 years waiting for a matric certificate. He testified that outstanding matric certificate does not cure the misrepresentation. Employer's case. Testimony of Mr. Alvin Flopper. The employee never gave testimony. The employee's case only led the evidence of Mr. Alvin Flopper. The employee's witness testified that he was appointed by the SABC and further that from his date of appointment, he never left the employment of SABC. The witness further testified that during 1994, he was tasked by the SABC to make SABC newsroom and political desk more representative in reflecting language needs in the SABC. The witness was appointed in the above position by Mr. Reddy, whom at the time was head of radio for the Free State newsroom reflect democratic of SABC audience. The witness testified further that it was strange for him that Free State with Southern Sotho speaking was looking for a Sotho speaking candidate. The witness recommended Mr. H. Mutsoening for a position as a trainee journalist and has considered during his testimony that thereafter was not involved in the actual appointment of Mr. Mutsoening. The witness placed vision that he was well aware of the fact that Mr. H. Mutsoening did not have a matric certificate, standard 10, and further that SABC at all instances was aware of that fact. What the witness failed to inform the chairperson of is to whom specifically as representative did he inform of the fact of hand. And further, what appears more strange is that the fact that he went to an extent of disclosing similar facts to the public protector when investigating was conducted in a public interest, which in conclusion should have not been the case given the legal duty thereof. The witness further confirmed in his testimony during cross-examination that when recommending Mr. Mutsoening, he has never in any point in time had Mr. Reddy indicating that the position required a trainee journalist who did not have necessary matric certificate. The witness sought to mislead the proceeding by further stating that Marie was just a mere administrator, notwithstanding that the letter confessed that himself during employment of the SA had never met Marie, whom wrote the note that the matric certificate were outstanding, though can confidently identify Marie's position as that of an admin officer. The witness did not end at that. He further made an allegation that appointments were conducted by SABC in Johannesburg offices, but did not testify as to why did the appointment of Mr. Msweni held in Free State. As from the record, the appointment was submitted in the Free State. The witness confirmed that the handwriting that appears on the first and second page of the form is that of Mr. H. Msweni, though some writings does not appear on the third and the fourth page of the employment form. The witness sought to convince the proceeding that the appointment was conducted prior to the filling of the form, but he failed to place in confidence as to the purpose of the employment form if he was already appointed. If he was already appointed without that form, that would be what I want to say. From the above, it is clear that the witness was evasive and was solemnly called to mislead the chair and protect the ulterior interest of the employee. Analysis of the evidence. From the above evidence presented, employee represented or dishonestly presented facts that were incorrect, which motivated the reasons for the employee's decision to enter into an employment contract, influenced the said false representation. The witness of the employee, being Mr. Klopper, testified that the employment of the employer allegations were advanced that the employee does not have a matric certificate upon recommendation he made. It is the employer's submission that the allegations the testimony should not be considered on the basis that he did not disclose fact to the relevant department tasked for appointment, and further that the testimony was not supported by evidence. It is the employer's submission that the employee at time presenting his application, he deliberately mispresented the incorrect facts with an ulterior motive to be employed by the employer. In the case of Miyambo versus CCMA and Adada, the court held that the business risk is predominantly based on the trustworthiness of the company, employees, and that the accumulation of individual breaches of the trust has economic repercussions and can be detrimental to the integrity of the company. In the present matter, it is clear that the conduct of the employee constitutes a dishonest conduct, or alternatively that in the event the chair believes that he had disclosed the issue of a matric certificate, that his non-disclosure in the fact constitutes dishonesty, which took place in relation to employment. The facts in Miyambo Supra are similar to that in this case, in that there is direct evidence of dishonesty in relation to the employer, and the labor appeal confirmed the finding of the labor court. It is the admission of the employer that the dismissal of the above employee on evidence-led and proven facts that, considering the terms of schedule of the Code of Good Practice, dismissal will be appropriate discipline, given the following: that the conduct of the employee amounted to a clear misconduct in that he presented an incorrect information in his application form, alternatively fail to disclose facts inherent to the requirement of this position. Therefore, a dismissal will not be considered unfair for the effect fair reason given above and in accordance with the fair hearing given to the employee followed. The schedule further provides that the determination of whether or not dismissal is fair is the reason determined by the facts of the case and appropriateness of dismissal as a penalty. The key question on which the chair has to ask himself or herself is simply, was put in Engine Petroleum versus CCMA and others 2008 BLRR 707 LAC, which is as follows. This is a dismissal. Is this dismissal fair? In dealing with this issue, in that the case, the LIC had this to say. The ordinary and natural meaning of the word fair suggests that commissioners must answer the question on the basis of their own sense of fairness. The question cannot possibly be answered on the basis of somebody else's notion of fairness. This was position adopted by the court in the 1956 Labour Relations Act. There is no basis in assuming that the question has changed under the new Labour Relations Act. In this aspect, the Constitutional Court is to state the following. It is practical reality that in the first place, it is the employer who hires and fires. The act of dismissal forms jurisdictional basis for commissioner. In the event of unresolved dismissal dispute, the conduct of arbitration in terms of LER, the commissioner determines whether the dismissal is fair. There are therefore no competing discretions. Employer in the commissioner each play different part. An impartial third party determines on whether or not a dismissal was fair, likely to promote labor practice. The Constitutional Court went further in paragraph. In approaching the dispute impartially, commissioner will take into account totality of the circumstances. He or she necessarily take into account the importance of the rule had been breached. The commissioner must of course consider the reason of the employer imposed the sanction of dismissal as he take into account on the basis of employer's challenge to dismissal. There are other facts that will require consideration. For example, the harm caused by the employee's conduct, whether additional training or instruction may result in the employee not repeating the misconduct. The effect of dismissal on the employee or his or her long service of record. This is not exhaustive. In the present instance, the chairperson in concluding the dismissal as a sanction should locate the basis of conclusion in what is found to have been the consistent application of discipline by the employee. In Nganga v. the CMA, the Labour Appeal Court, in confirming the decision in Ivan v. Johnson, 1999, 20 ILJ 2303, held that disciplinary consistency is the hallmark of the prosecute labor relations. In every employee must be measured by the same standards. The court went further to say, when comparing employers' care should be taken into assure that the gravity of misconduct is evaluated. Another important aspect of assessment of the employee's case, the chairperson must evaluate that evidence showing that trust relationship between the parties is broken down. The argument accords with the view expressed in De Beer v. Consolidated Mans v. Commission for Conciliation and Mediation and Arbitration 2021 ILJ 1051. At paragraph 17, where Candle J. A. in dealing with what ordinarily could happen when it is found that the employee had committed a serious misconduct. In this respect, the learned judge had this to say. The commissioner characterized the misconduct as serious, despite that he should consider the relationship of trust between the appellant and the employees not broken. Where the employee has committed a serious fraud, one might reasonably conclude that the relationship and trust between her and the employer has been destroyed. When the employer then asserts that this has in fact happened, it would be statement to her to hear a commissioner's proclaim that despite what might expect and despite what the employer says in fact occurred, the relationship of the trust had been broken. What is important, however, is what is said in the last part of the above paragraph. Well, Judge President say, of course, a commissioner is not bound to agree with the employer's assessment of damage done to the relationship of trust between an diligent employee. But in case of fraud, particularly serious fraud, only an unusual circumstance will warrant a conclusion that it will be mended. The approach similar above made Colonel J.A. in DBS consolidated matter was followed in the case of Standard Bank vs. CCMA and others 1998 9 ILJ 903, where the court held that dishonesty in general renders the employment of the relationship intolerable and incapable restitution. It is clear from the above that the duty to show that the trust relationship between the employer and the employee is broken down due to an act of serious misconduct rests with the employer. Lambo J in the recent unpublished case of Edcon Limited versus Hilema NO and others case number 191/08 held that Hilema was entitled and in fact expected in the scheme of things to explore if there was evidence by Edcon or record before her showing that dismissal was appropriate sanction under the circumstances. This was because Edcon decision was underpinned by its view that trust relationship had been destroyed. They could find no evidence suggests that alleged breakdown or specially mentioned in this as one of reasons for concluding that ready dismissal was inappropriate. In reading of the weight further reveals that in addition to this finding, Hilma also found that the context of the matter Ready's long and unblemished track record was also important considering determining appropriateness of the dismissal. Conclusion. The employee should be found guilty of 3 charges on the basis that even his version was not placed before the witnesses. I must indicate that when the witnesses was testifying, I never had any evidence to the effect that my client's version regarding this is as following. That didn't happen. Unless the chair had that. It didn't happen. To now, the employee, well represented, we do not know his version. The witness of the employer corroborated each other in all material terms. I never had, during cross-examination or whatsoever, question being posed that so-and-so said this and now you are changing his version. The witnesses corroborated each other. If that didn't happen, my colleague, well esteemed, was going to say that I heard so-and-so saying that and now you are saying that. That didn't happen. Throughout the proceedings, they corroborated each other. Evidence of the witnesses was never challenged by the employee, and it is common cause that the version not rebutted stands. I never also heard their evidence being challenged. They testified, and now they are gone. And we can't recall them, but this stage is a stage of argument. The employee failed to testify, notwithstanding being well represented, and the principal in the case of Oseli Frankel, AUBOWN Kassen versus CCMA and others, case number 2C260, 2003, where the Honorable Murphy A.J. held as follows. I need to read it very, very clearly. This is an important case. That in the employment law context, where there is evidence directly implicating the employee in misconduct or in adverse to his or her version, such an employee cannot afford to leave the evidence unanswered. Chair, we are sitting with an employee. There is an application, there is an employment form filled with his details. We do not know his version. It was never put to the witnesses. Witnesses are testifying that he filled the form, or the details that appear are his details. Witnesses come here, testify that he said, "Kito tsibela." We don't hear it saying that it didn't happen. And that was prior to the disciplinary hearing. That we didn't hear it happening. My colleague, esteemed and experienced, didn't put that to the witnesses. He didn't. Unless maybe I was asleep during the proceedings. But I didn't hear it. Number 3, this matter is in a public eye. There has been a public protector. There has been a Western Cape judgment. There has been a Supreme Court judgment. This matter is in the public eye. We were expecting the Honorable Mr. Mutsonin to clarify his position and testify and tell the public as to what happened. The Honorable, Mr. Klopperson himself, when testifying, he said he has discussed this with Mr. Mutsonin that he doesn't have a matric. Perhaps the Honorable Mr. Mutsonin was supposed to come and tell us and say, all right, this is who I told that I do not possess a matric certificate and I don't have a matric.
Perhaps, Mr. Palani, you should convince me.
Oh.
The cameras.
Okay. Thank you, Chair. Chair, I must say that such didn't happen. We are sitting with an unchallenged evidence. We are sitting with a matter that is in a public eye who we do not know the response. We do not know the response of the employee at this moment. And I will humbly submit that an adverse inference should be drawn. If the employee trusted his version, he believed he was honest from the beginning, why he didn't tell the chair on the inquiry and of his status? Why that didn't happen? Why? There was a serious evidence. It's not the case where no evidence was led at all. I will use the criminal law example. If this was if for instance, I will use the example of Section 174, although I know it's not material.
Of the criminal procedure?
Yes. Section 174 states that if there is no evidence, the court should accuse the accused without him testifying. I'm just giving a general elaboration. But in this instance, evidence and concrete evidence of the form, witnesses, was led. That evidence was supposed to be challenged. We were supposed to hear from him as to what happened. No one can come here today and say, I know what happened to Mr. Busweni's form. No one. He is the one to tell us. The fact of the matter, we are sitting with the form with his names. Standard 10.
Let me just, I don't want to interrupt you unnecessarily.
Yes.
But you're saying the onus is on him.
Yeah, exactly.
Is that what you're saying?
Yes.
Why?
The form that was there.
No, I understand in what context. Are you
Yes.
saying that
Yes.
you have given enough evidence
Yes.
he should come and rebut? Is that what you actually are?
Yes.
And failure thereof, I should draw at first inference of his silence. Is that what you actually say?
Yes, yes.
All right, then I follow you. Okay, go ahead.
Let me just go to the next paragraph. This, otherwise I'll be very long on this. The employer submit that the dishonesty and clear abuse of power as per the testimony of the fourth witness constitute good grounds for dismissal as they frequently constitute a fundamental breach of the employment contract. In the presence of the case, it is given the past with the reason the breach of relationship of trust that occur on an employee is this paragraph the employer and the employee are parties to the enterprise and produces broadcasting service to the Republic of South Africa. If the employee in the regard is dishonest to this degree that the enterprise or the part of it is jeopardized, then the employer is certain that there has been such fundamental breach of employment relationship. The court have frequently upheld dismissal for dishonesty. It is not an invariable rule that offenses involving dishonesty necessarily incur in the supreme penalty of dismissal. The fact of this very case must be assessed and the aggravating features taken into account. At the close of the employer's case, the employee exercised its right to remain silent and has therefore not rebutted the employer's case. The principal applicant this kind of situation has been set out in SABC 2000, ZACC 25, 2001, SACR 1CC. The Constitutional Court had to deal with the question whether the applicant contention that his right under Section 35(3) of the Constitution to remain silent and not to testify during the plea was infringed by the SCA or not. It was contended, among others, that the SCA improperly relied on the applicant's failure to give evidence to conclude that there had been proof beyond reasonable doubt. At paragraph number 9 to paragraph number 2, Langat DP laid down the principle with regard to the right to remain silent as follows. The fact that the accused person, this is a criminal case, but we are dealing with I will explain the relevance. I must not be quoted out of context. I know we are dealing with... Yes. The fact that an accused person is under no obligation to testify does not mean that there are no consequences attaching to the decision to remain silent during the trial. If the evidence calling for the answer and the accused person chooses to remain silent in the face of such evidence, a court may well entitled to conclude that the evidence is sufficient in the absence of explanation to prove guilt of the accused. Whether that conclusion is justified will depend on the weight of the evidence. What is stated above is consistent with the remarks of Madala J, writing for the court in Osman and others, is the Attorney General of the Transvaal, when he said the following: our legal system is adversarial. One, once the prosecution has proceeded with evidence sufficient to establish a prima facie case, an accused who fails to produce evidence to rebut the case is at risk. An accused, however, always runs the risk that absent of any rebuttal, the prosecution case may be sufficient to prove the elements of the offense. The above-mentioned rule was derived from the common law approach, which was in R. Shelele and others, Dindal J.A. reply in English decision of R. Lake. On the basis of the above, the employer submit that the charges were proven on balance of probability. That is the argument for the...
Is there anything outside the edge you'd like to convey to me? Or is this your argument?
What I can say is that we don't have his evidence. Concrete evidence was led. The witness that testified at some stage he didn't have answers. And those answers were supposed, Mr. Mutswene, to give it to us so that we can conclude on this matter. And as things stands, I will submit that only our evidence stands. Only our evidence stands.
Is there anything else?
Nothing.
All right, before I ask Mr. Majabu to address me, there's two things I'd like you to address me on.
Yes.
The first thing is Exhibit E for ECHO, the application form.
Yes.
You will remember I allowed it provisionally.
Yes.
First thing was in camera, which we've dealt now with.
Yes.
Second one was Exhibit E, which is provisionally still before me.
Yes.
You have not addressed me on authenticity of that document. I see that you've submitted that Mr. Motsono, that Mr. Kloppers had testified that Mr. Motsono had filled it in. I don't find that evidence. But be that as it may, let us not go there. I'll make my ruling. But the point I want you to address me on is Exhibit G, why I should allow it, because it's provisionally before me. What evidence should I allow that document in the light of the following? One, it's a copy. I specifically asked you where the original was, and you said your answer was it's not in the file. In terms of the best evidence rule, I accepted it because the original is now gone. I don't know whether it's a true copy of the original. You have to address me on that. Because you will remember there were all sorts of allegations, the handwriting differs and the page is gone, with all sorts of problems. You understand? And I specifically asked Mr. Klopper, can he tell me who is the author of that document? Do you remember that?
I remember.
Or whether he's got information of who wrote on that document. You understand? I want you to address me on that. Because I have to make a ruling with whether that document is admissible before me, and if so, what evidence value does it carry? You understand? That's the first thing I need you to address me on. I'll ask Mr. Majabu the same question. He must listen to what I'm asking you. The second thing I'd like you to address me on is Exhibit F, because that's also provisionally before me. That's the Kleinans internal audit that you did. Remember that?
Yes.
I allowed that document provisionally on the basis that you were going to call her. And then in the end, when you applied for postponement to call her, I ruled that I would not grant you that extension. And I will deal with that later in my final ruling, why I did that. But I need you to address me on whether I should accept that document or not, and you haven't. You understand?
Chair, I will address you on
So those are two basic things that's provisionally still before me, which you must deal with.
I will rule that the exhibit.
No, you don't rule. You address me.
Chair, I apologize. I wanted to say.
Thank you, sir.
Maybe one day I will be a chairperson of another.
No, that's fine. That's fine. That's fine. Perhaps you must think of these things I've asked you. I understand.
Chair,
Let's start with E.
I will submit that it should be allowed.
Yes.
Firstly, nobody disputed that this was in there.
No. Mr. Majabu objected to the document, and I allowed it provisionally. But I want you to now address me why I should still allow it, you understand, as a final document, which I should take cognizance of it, and if I do, what evidential value does it carry? You understand the two different terms?
I do understand.
All right.
I would submit that the original is law. I don't know what happened to the original, but the original is.
You've got a problem with that, you agree? Because you have not told me where is the original and why is it not in the file, and I accept you have had ample time now to come and tell me that, or the evidence.
Yes. In consultation with witnesses, particularly Mr.
No, but I don't want to hear that, what you've got consultations with. I was what was
my instruction is that nobody knows what happened to the original.
So you're telling me that from where you used to sit now? Nobody knows?
Yes.
Because that has not been testified yet. But I accept what you're telling me.
Yes.
All right?
And I will further submit that, that document bears the details of...
Yes, I understand that argument. I followed that.
Yes.
I'm not at that point. I'm at the point where I have the following problem, which I enhanced to you. And the first thing is, it's a duplicate, it's a photocopy. You have told me why that is now a photocopy, but how do I now make the inference that it is a copy of the original? You understand? That's my problem. Because there are allegations here in the evidence that the handwriting is differing. I don't know who the author of that document is. Is it Swanepoel? Is it Motswaneng? Is it whoever? And there's a page missing of a signature. You will remember Mr. Klopper said it was that of Mr. Motswaneng. He saw it. But is it still the same document as it initially was in the file of HR? And that's a very important document. And you have to convince me that I should accept it, as well as the contents and why.
Chair, I will submit that if that was not the case, the employee will have put that to the record.
No, okay. I just wanted to give you an opportunity to address me on that, so that you know that you think of these things which I have to deal with in my ruling. And if you want to deal with it, please go ahead. But if you stay with what you've said, then I accept that is your argument. You understand?
I'll stay by my argument.
You stay with it.
And add that if that was not the form, Mr. Mutswaneng still had an opportunity. I must place it on record. It's important. I know you'll make a ruling. Had an opportunity to come and tell us, and that this is not the original, this is not me, and he didn't do that.
Yes, but you obviously also know the onus. You've argued criminal cases which the onus is completely different as in these areas, which is much more tough, beyond a reasonable doubt. This is not the situation here.
I know
and I understand the principle that you were trying to get to me. I follow that, but that is not what I'm busy with. What I'm busy with is that you must. You carry now the onus to convince me why I should accept the exhibits that you handed in, which I accepted provisionally. And one of them is Exhibit E, and if you want to stay with what you've argued, and I've told you what my problems are, then that is your argument.
Chair, that will be my argument.
The second thing I want you to address me on is Exhibit F, because it was handed in through Mr. Goma, because his name was in it.
Yes.
And I specifically asked you at the time, why are you presenting the document through this witness? And then you argued that you would qualify it at a later stage with the Vigaboke evidence of the author of that document, which you have now failed to do. Now, my argument is, do you want me to take cognizance of the content of that document? And if I do, I could only do that if I make the ruling that I accept it formally now. It is now provisionally before me. And if I do that, for whatever reason, what is the evidential value which is untested in that document?
Well, Chair, on that aspect, our view was that we will be allowed an opportunity to call the witness, and that didn't happen. I will leave it in there.
Yes, I made my ruling for the reasons I'll give you later, but I made the ruling.
Yes.
The point is, it seems to me that you have difficulty now to argue under the circumstances that it was admitted provisionally on F.
Chair,
or is there any other reason that you can...
There's no other reason. Obviously, that document, the author of it is the one that says it will be here on the 11th of January, and that obviously that opportunity was not given.
Yeah, but you never gave me reasons why. And you never let any evidence why, and what was done, and what the hiccups were, and all those kind of things which I will deal with later. But I point out to you that you must now address me on whether I should admit that document.
I was going to lead evidence through that witness.
Yes, okay, now I follow,
yes.
But
the aim on that day of having to bring that document provisionally was that the witness that was testifying, his name was in that report, and I did not want, after the witness has left, and then I start talking about it.
Yes,
that is what
I think we assist you that you follow what I need from you.
Yes.
Although I've made my ruling on whether I grant that postponement or not, I don't mind giving you another opportunity to address me. You see, at the point in time, you obviously would accept that there are many due processes how to get witnesses here. You've never addressed me on that, or what you had done, or the reasons for the witness why it couldn't be here, and this and all those kind of things, you understand? And it doesn't help you telling me now that because I've made my ruling and which I will deal with. I'm now dealing with the fact, what do you want me to do with the exhibit that you'd handed in provisionally under those circumstances? And it would not be fair of me if I don't give you that opportunity because you have not dealt with it.
Chair, I'll leave the ruling in your hands. I do not want to.
Thank you very much. Thank you, Mr. Manjavu.
Chair, on a lighter note, perhaps a useful starting point would be to say to my colleague, he would be well advised to leave my esteem and experience and rather focus on trying to persuade you. Having said that, Chair, I propose to deal with my submissions in 3 phases. The first phase would be where I deal with the submissions made by my learned colleague. Would be where I deal with my own submissions. The third and final phase would be where I attempt to persuade you in a particular direction and deal with various questions of law that you have raised. And perhaps as a subset of my final phase, I would attempt to deal with the issues that you have canvassed now with my colleague, to the extent that you had indicated that I must listen carefully as you were going to expect me to address you on. I was in any event going to do so because I was the originator of the initial objections. With that out of the way, Chair, my colleague spent 2 minutes 47 seconds dealing with the testimony of his entire witnesses. The last 23 minutes he spent dealing with sanction, dismissal in particular, and he quoted a litany of cases. I admire my colleague's optimism, but before we get to that point, he must first get past a conviction. Then we can talk sentencing. I will therefore not waste our time and deal with that. Obviously, at the appropriate stage, if and when my client is convicted, I know, as a matter of law, I would be afforded an opportunity to place mitigating factors on record. And similarly, my colleague on behalf of the employer would have the same second opportunity again to place what he regards as aggravating factors on record. So I elect not to deal with that at this stage. The second issue I want to get quickly out of the way is the fact that my colleague seems to be making an issue to a point of grandstanding about the fact that my client elected not to testify. It was not a mistake. We submit it as a carefully considered decision which is permissible in law. My client bears absolutely no onus to plug the holes in a limping case of the prosecution, either in labor law or in criminal law. There is no such responsibility. He may have had an opportunity to clarify certain things, but he's certainly under no obligation to do so. I am not suggesting for a second that his election not to testify is not without consequences. You see, it is fashionable to refer to cases, and the case that my colleague referred to exactly makes my point. It was a Constitutional Court overturned the SCA. I know this case because I recently used it. In paragraph 5.14 of my colleague's heads or submissions on page 24 for your ease of reference, Chair. Page 24, paragraph 5.14. I just want to demonstrate the fallacy of this argument. If anything, it tends to support my case. It was contended by the Concord that the SCA had improperly relied on the applicant's failure to give evidence to conclude that there had been proof beyond reasonable doubt. What had happened there? The SCA visited an adverse inference upon the appellant on the basis that he had not taken to the witness stand and therefore drew an adverse inference, as my colleague is inviting you to do so. But he does so on the back of a Concord order that corrected that fallacy. The point I'm making is that legally there's absolutely nothing wrong if my client elects not to take the stand. The question and the test that you, Mr. Chairman, as a trier of fact would have to deal with is whether or not there is a consequence for him having made that election. But that you have to counterbalance against the value and the quality and the evidential weight that you attach to what is placed before you. It is not good enough to say, but witnesses testified, he had an opportunity, why didn't he? It's not your job to speculate and imagine what could have been. That point is actually buttressed in the penultimate sentence at the end of that paragraph. A court may well be entitled to conclude, and so it goes. It doesn't say the court shall. There is a vast difference. May well be talks to a discretion that must be exercised by the trier of fact, which discretion is exercised judiciously. That puts paid to that invitation that you must draw an adverse inference simply because my client, very well on my advice for that matter, elected not to take the stand because it remains our considered opinion, view, that he had no case to meet. I'm sorry that we didn't come to your rescue, but that is the law, and that is how the legal principle is applied. He says there was a form. Because Mr. Mutwening did not dispute the presence, existence, and authenticity of the form, we must accept that it must be his form. There is a difference, a fundamental difference, Chair. I assert the mere fact that my details make its way on a form, and those details of mine as so recorded in that form are correct, does not necessarily mean that I am the originator of the form, firstly. Secondly, he sought to say to you, Mr. Klopper said it was Mr. Mutwening's form. Mr. Klopper could not have said that. What he said was, on the first page, the biographical information looks to be that of Mr. Mutwening. And in fairness to Mr. Klopper, he said, actually, I have no way of knowing what happened down there because that happened in Bloemfontein. I was in Johannesburg. I do not know who completed it. I do not know the ongoing so on. What he also did say, he said, it was shoddy HR work. Had that happened in his office, we would not be sitting here. And I wanted to dispel the myth that even Mr. Klopper said. It may well be that that is Mr. Mutwening's form. But there is no such evidence that was laid before us. I was not sleeping, Mr. Palani, when I raised the objection. It was precisely because of that point. To say, if we are to accept that form to be what it purports to be, there's got to be a proper basis laid for it. And it was on that basis that the chair allowed it provisionally. It therefore cannot be true to say it was not contested. I may not have used the words that you are normally used to in common parlance, but the point was made that we do not accept it. Hence the objection. As a matter of fact, that form is undoubtedly incomplete. The employer's own witnesses said so. 2, they also considered that it cannot be said to be in chronological order. The closest they came to casting aspersions on Mr. Mutwening was Mr. Paul Tati, who said for some reason he remembers that the missing page was there when he was at the SABC, but now it is not there. I don't want to get into that. I'll deal with Mr. Paul Tatu and analyze his evidence. Safe to say, even on his own admission, he accepted that that form is incomplete. And the part that is missing is a part that ostensibly would have borne Mr. Mutwening's signature. That is the high water mark of Exhibit E. What weight, if it does pass muster and it is admitted into evidence, to be attached to it, we submit little if no evidential value at all. And of course, in the fullness of time, that is a decision that the chair would make. But nothing that was said by all the state witnesses came close to even lending credence to the invocation of the best evidence rule. That is a fact. Even the very book that you have there next to you would tell you that. Having said that, let's deal with this issue that Mr. Kloppers was an untrustworthy witness. I am dealing with it insofar as it arises directly from your submissions. Nothing could be further from the truth. What Mr. Palani, with respect, is not telling you, Mr. Chairman, is that Mr. Kloppers was originally on their own list of witnesses. He or someone from the employer sent me on my 6th request for a list of witnesses, a list. One of those people in that list was Alvain Kloppers. I only elected to call him when the employer itself decided, for reasons best known to it, not to call him. And as a matter of law, if the one party elects not to utilize a witness that it had, there would be no legal impediment in me utilizing that witness. As a matter of fact, that witness still falls under the jurisdiction of the employer. You would remember, incidentally, Chair, when we adjourned yesterday, I gave my colleague advanced warning on record, and I dealt with it under the heading of housekeeping logistics. I said the following: may I, and this was after he had indicated that his only outstanding witness was LCG Oosthuizen, whom he was going to bring an application to deal with after he had led Paul Tati. So we knew as at that stage that the outstanding witnesses on the employer's list were Paul Tati to be led the following day, and LCG Oosthuizen to be led on or about after the 11th of January 2016 when she returns from holiday. At that point, it became apparent that they were not going to be using or utilizing Mr. Alvain Kloppers. I then said here on record that I am going to be asking the employer to assist me to secure the attendance of those employee witnesses in their employ whom they are not utilizing. And I told my colleague, didn't hide it, said, in the event you were to close your case, please do note that I am going to go straight into the employee's case, and at best, I may lead 1 or 2 witnesses, but the one that I require assistance with is Alvain Kloppers. Now let's talk about the adverse inference. I actually like it that he even ventured the thought. I am going to invite you, Chair, in the fullness of time, to draw an adverse inference against the employer to say this was their own witness. This witness had always been available to them, to the public protector, to all and sundry. And they elected not to use him. The big question is why? And in the answering of the why is my invitation for you to draw that adverse inference. And I hazard a guess to say it is because they knew that his testimony would not support or substantiate the charges leveled against Mr. Mutshweni with specific reference to count 1, the sensational aspect relating to him having falsified his matric results. Because the employer was already in possession of his affidavit, the one that he deposed to in 2012, which was requested from him by the employer, SABC. So they were privy to the contents of that affidavit, which was handed in, not provisionally, but was properly handed in as an exhibit. And the content thereof is self-explanatory. It strikes right at the heart of the allegations contained or encapsulated in count 1. I am therefore asking that you take judicial notice of that fact, and having done so, you draw an adverse inference against the employer. It cannot be because he was going to exonerate my client, therefore he is not a good witness, when they themselves wanted to use him. They abandon him, I use him, then it's a problem. There is absolutely nothing in his testimony that suggests even remotely that he was not a credible witness. In fact, language as high as, I quote, the witness sought to mislead the chair. He had absolutely nothing to gain by misleading you. Absolutely nothing to gain. In fact, when concessions were called for, he made those concessions quite outrightly. My colleague also said, when he was giving you a 2-minute noodle summary of what Mr. Goma had to say, he said, Mr. Goma said he suffered abuse at the hands of Mr. Motshweni. Now I am going to direct, Chair, I know you might not have a hard copy of the transcript yet, but I will just give you the reference so that you can verify in your own time whether what I'm saying is Majavu speak or is it what was said by Mr. Goma.
Right.
I'm directing, with respect to your attention, to page 22 of the record of the hearing of the 9th of December. I sent my colleague an electronic copy of the record as well, the transcript. And I'm going to direct your attention to a question that he put to Mr. Goma. And you can draw your own conclusion. On or about line 13, 1-3.
Just a moment. Page 22.
22, paginated at the top, in the middle.
Yes. Line.
On or about line 13, Chair, Mr. Palani. This is Mr. Palani speaking. Can you,
I'm not following you.
yes, I'm quoting Mr. Palani in the question that he put to Mr. Goma.
It's page 22 of the record.
Yes, of the hearing of the 9th, Chair. You are looking at the hearing of the 7th. I beg your pardon. The 9th. Mr. Goma only testified on the 9th. Page 22.
Okay, yeah, they're not paginated. They get new numbers every time they get typed, as we got a running record, correct?
No, they are paginated differently. See,
Yes.
there,
Yes?
there.
I'm with you now.
Thank you very much, Chair. I don't know if my colleague has access to his electronic copy or
That's fine.
will you follow?
Yes.
Okay. No, that's fine, thanks. I just wanted to make sure that this was in the context of him leading Mr. Goma on a number of issues. And then he took out the gloves and he got straight to the issue of how Mr. Goma could have been fired or otherwise dealt with unfairly by Mr. Motshweni. He said, I quote, this is Palani speaking, can you say that Mr. Motshweni was involved in your constructive dismissal as you put it, question mark? And you will see there, Chair. Mr. Goma replies, I reported to Mr. Fulmilefo and the second in charge, and for the next 5 pages, attempting to give an answer to that question. And I'm not going to read the entire, I just want to make a simple point, that he mentioned anybody and everybody that he felt aggrieved about, excluding Mr. Motshweni, in a direct response to a direct question that he put. Whether or not I am misleading you, Chair, I am sure you'll read that record. But the point I'm making is that in response to that direct question, he complained about Phil Molefe, Gif Mgomezulu, and everybody else except Mr. Motshweni. The same narrative continues on page 49 of the same transcript. Now, this is when he has now come to the end of this morning session of his. I then put a proposition to him to make sure that I followed what he said in response to a direct question about him having been dismissed or unfairly dismissed by Mr. Mutweni. Majavu, this is now Majavu speak. Now, would I be also correct in saying, or I understood your evidence to be saying that you are unaware of any abuse other than the instances that I have referred to that could be said to have been visited upon you by Mr. Mutweni? You only mentioned Mutwening's names in two contexts. The reason I am mentioning these other people is to say that is the answer you gave when Mr. Palane asked you a question about the abuse of power by Mr. Mutweni. Did I understand your testimony correct? This is Majavu now putting it to Koma. Koma replies, Mr. Majavu, through you, Chair, you understood me correctly. Majavu says, okay, thank you. Mr. Koma says, okay. I leave that issue at that. Chair, I now tend to deal with the second phase of my submissions. I confirm, Chair, that I had prepared a 30-page strong written submissions. I will not read the entire 30 pages verbatim. I will only direct your attention to those aspects that I believe are salient and require amplification, unless, of course, you direct me on any specific issue that you may require clarity on. I start off by setting out the chronological background that indicates the genesis of these proceedings. I do so, Chair, mindful of the fact that we had always argued that time is of the essence. And in some of the interlocutory rulings that you made, they were made informed by that. So it is important for us not to lose sight of where this all started. These particular disciplinary proceedings were kicked off by the employer, the SABC, serving the charge sheet on Mr. Mutweni on the 12th of October, pursuant to a court order, that court order itself being on the back of a report of the public protector. Mr. Mutweni accepted service of such a charge sheet on the same day, which therefore means that in terms of the court order on the back of which these proceedings were initiated, they had to be completed within 60 days, reckoned from the 12th of October. On the next page, I simply recite, for the sake of completeness, the relevant portion of the court order, and also, for the sake of completeness, indicating what the court directed should be the charges to be preferred against Mr. Mutweni. The portion that I've highlighted there is a direct lift-off from Skipper's J's judgment. That there were subsequent challenges in higher courts is a given, but nothing turns on it, other than to say the original application brought by the DA was brought in two parts, Chair. The first part was the one that sought to obtain the immediate suspension of Mr. Mutweni, which we managed to deal with in a number of other unrelated court processes. The second part, which bore relevance to the first exhibit that you accepted, and I'm trying to bring it closer home, is the part that had to do with the review of his permanent appointment as the COO. That matter served before Davis J, and in the ultimate end, he ruled on the 27th of November that his permanent appointment of COO is reviewed and set aside. The date is important because it was handed down on the 27th of November. After Mr. Mutweni had been served with a notice of the charges on the 12th of October, the Part B matter was argued pending the DC hearing. And in fairness to the Honorable Judge, he also indicated that this piecemeal arrangement does not make for good law. He even invited the parties to consider the possibility of standing down the hearing of the Part B pending the finalization of these DC proceedings that had already been initiated in the form of serving a charge sheet on Mr. Motshweneng. At the end, there was no agreement. The matter was fully argued. He reserved his judgment. As per the charge sheet served on him on the 12th of October, the employer had unilaterally determined the date of the hearing of the DC to be the 30th of October. On the 30th of October, myself and Pure Mr. Motshweneng, we rocked up at the hearing to be chaired by Advocate Enquiry SC, and the initiator was to have been a good colleague of ours, Mr. Sandile July of Waxman's Attorneys. On that day, the 30th of October, the judgment in respect of the review Part B before Davis J was still reserved. Now, when we were supposed to commence the proceedings on the 30th of October, through no fault of Mr. Motshweneng, the self-same employer was not ready to start. The employer's representative, Mr. Palani's two predecessors, asked for a postponement which I opposed. I was defeated in that a postponement was granted. The matter was consequently postponed sine die, with a directive that within 15 days, reckoned from the 30th, being the date of the first hearing, the employer and the employee's representatives must hold a pre-hearing meeting at which, we were supposed to deal with all these preliminary issues. We did that within 3 days of that directive, whereafter we went back to the presiding chair and we all reconciled our diaries, and it was agreed that this matter will proceed between the 1st through to the 4th of December, and there will be no indulgences, no postponements. That was agreed. Before we resumed on the 1st of December for the continuation now of these disciplinary proceedings, on the 27th, which is the Friday preceding, as fate would have it, Davis J delivered his judgment in the outstanding review matter, in terms of which he reviewed and set aside Mr. Motshweneng's appointment as permanent COO. He did not terminate his employment relationship with the SABC. On the Monday, when we reported for the continuation of the DC, the Tuesday rather, the 1st of December, we were then informed that for reasons unknown to us, Mr. July is now no longer the prosecutor. We were informed then that Mr. Mpoya Maledwaba was now the new prosecutor. Our approach was very simple. Doesn't matter who prosecutes, doesn't matter who chairs, let's just get this show on the road. Mr. Ledwaba himself took it upon himself to further brief counsel to prosecute on his behalf at the same proceedings. We took the point that as a delegatee, he does not have the power to on further delegate. It's an established legal principle. We were told that the board of the SABC had in fact given him the requisite authority, and such authority would be handed in the following day. The second issue that we had to deal with on that day was an invitation, in fairness to the presiding chair, to say he would be remiss if he would not invite our responses on what he regarded as a material intervening factor in the form of the judgment by Davis J that had been delivered the Friday preceding. Incidentally, the employer said, by the way, we're also going to take that point. So he then said, why don't you then address us? I said, Chair, I'm ready to address you here and now on this issue. The employer said, no, we're not ready. We want an opportunity to go take instructions. I took the point again to to say, a few minutes ago, you were going to take the point. The chairman invites us to address them. Now you are not ready. So it means another further day gets wasted. I was overruled. The matter was rolled over to the 2nd of December. And on the 2nd of December, we were to address the presiding chairman on whether or not the judgment of Davis J. had an impact on these disciplinary proceedings or not. On the 2nd of December, we rock up again with my poor client. That counsel that had been appointed disappeared. Mr. Ludawa says, no, he will carry on. We say, sharpshoot, let's carry on. We made our submissions as to why these proceedings should continue regardless of what the order of Davis J. said. We made our submissions, which we provided to you, Chair, and I'm not going to take you through that. A ruling in that matter was reserved again for the following day. We are now on the 3rd of December. 2 more days to go on the allocated dates. True to form, Mr. Enquiry delivers his ruling, the effect of which, according to him, was that the judgment of Davis J. rendered the continuation of these disciplinary proceedings academic, and therefore he terminated them. Not Mutwening terminating them. For once, myself and the SABC were in agreement that the jurisdiction of the SABC over Mr. Mutwening was not ousted by that judgment. But the fact of the matter is the proceedings were now terminated by the presiding chairman. Chair, I immediately wrote to the SABC again to say we are now in limbo. Mr. Mutwening had gone on voluntary leave pending the finalization of the DC proceedings, which are court-ordered. He can't discipline himself. He's brought his head to the guillotine. We can't proceed for reasons that have nothing to do with him. Should he report for duty tomorrow, meaning now on the 4th of December, because there are now no longer disciplinary proceedings pending? No, the employer says, actually, he should not report for duty because we don't agree with the ruling of Mr. Enquiry. In any event, we have taken that judgment of Davis J. on appeal, which means its operation is suspended until the appeal is finalized. I write back to the employer, what is to become of these disciplinary proceedings? We hear nothing until on or about Sunday. When I looked at my emails, I realized that there was a short, very cryptic message to say the disciplinary proceedings will continue on Monday at 8 o'clock. We will notify you who the new former prosecutor is. And I thought the last time I checked, Ledoaba was the prosecutor that replaced July. We took the view that it does not matter again. As long as we can get there on Monday, get this thing over and done with, mindful of the timeline set by the court, not against us, my client, against the SABC. On Monday morning, we are notified that no. You're starting at 9. And Mr. Palani, whose surname was incorrectly spelled in the notification, is now the new prosecutor. We get here, Mr. Chairman, I learned for the first time that you are the presiding chairman. So Mr. Enquiry is also now off. Mr. Palani arrived at the time that he did, and he indicated to you and I that he too is not ready. And I gave him warning, point blank, to say, this is not on. As and when we go on record, we are going to object. So as a colleague, I'm not taking you by surprise. We addressed you in chambers, and the decision was then taken that he must take some time to consider his position, because at that stage he had 3 witnesses present. Collegially, I understand his challenge. He had just been instructed recently. He needed to get his feet on the ground. But quite frankly, that is no problem of mine or my clients. But we nevertheless accepted that it is what it is. At 11:45, when we resumed, Mr. Palani requested a postponement. At that stage, there was talk of about 2 weeks or so. We objected. We were overturned in that the matter was rolled over. Provisionally, informally, there was even talk of us proceeding at 8 o'clock that evening, being the time that Mr. Palani indicated that his witnesses would be ready by. And on record, I asked to check that not only is he going to be ready, but we must check the witnesses' availability. You stood the matter down for 5 minutes to confirm that. He came back after whatever minutes and said the witnesses would be available. When you ruled that the matter must rather start afresh the following morning as opposed to 8 o'clock that night. And we only started 2 days ago with the hearing of the evidence by the employer's witnesses with all the interlocutories, which I will not go into. Which is why, Chair, yesterday, when my colleague, after having led 5 witnesses, when he sought a further postponement, I objected quite vigorously. And I succeeded in that a request for a further postponement was not granted. And I pointed out, Chair, that I am doing so to protect the very same employer that is charging me. Because it is that employer, the SABC, that is under a court obligation to finalize these proceedings within the 60-day period, which on my calculation expires on Saturday, day after, tomorrow for that matter. And therefore I could not understand why the employer wanted a further extension when they knew as far back as when we were in the SCA that we were submitting to the disciplinary proceedings. You were not told what efforts were made to secure that particular witness. There was absolutely nothing to justify why you should lean in favor of that request, having pointed out that a postponement is an indulgence that is sought from the presiding chair. It can be given or refused at his discretion, which discretion must be exercised judiciously, but there must be objective facts that are put before him. The pursuant to the refusal of the postponement, the employer closed his case. We immediately went into the employee's case. And it is not correct to suggest that the employee did not lead evidence. Evidence was led on behalf of the employee. The particular home body elected not to take to the witness stand, and there is absolutely nothing wrong with that. From a chronological point of view, Chair, that is where we are. And it was important to paint that picture for the record, so that there must be an appreciation of the trauma that my client has been subjected to. An impression has been created over time that he is this slimy character who's trying to avoid all of these things. But then one narrative remained constant, that he had always been willing and prepared to face his accusers in a disciplinary inquiry, which he has done to date. Charges were preferred. Now back to the real hearing. That takes you to page 7 of my submissions. When you look at exhibit, just bear with me, Chair, the exhibit that dealt with the charge sheet, the indictment, Exhibit B. That is indeed the charge sheet that was served on my client on the 12th of October. It listed 6 counts. If you read it that way, in its original form. When the charges were preferred, only 3 charges were preferred, and we had to renumber them accordingly. Fact of the matter is, the other 3 charges were not proceeded with. We accept that it is always at the discretion of the employer to decide which charges to put. Only point that I want to make is the following: that the charges that were mostly reported about in the media, that people made so much noise to the public protector about, that the public protector herself made serious findings about in relation to my client, were abandoned. As a defense lawyer, when charges are abandoned against my client, I welcome it. It's hallelujah. But in this instance, we had to make the point to say, it is very ironic that those charges about which there was so much media hype, about which my client was vilified publicly, made to be a corporate scoundrel, just get abandoned like that on the day of the hearing. With that in mind, Chair, if you go back to the judgment of Skippers J with regard to the remedial action of the public protector, because the SABC purportedly is giving effect to the judgment of Judge Skippers on the back of the recommendation of the public protector. I have great respect for the public protector, and so does my client. And in fairness to her, her remedial action was that my client should be disciplined. Beyond that, she did not prescribe how, by who, and how it should be done, because she too accepted that the factual allegations contained in her report, insofar as they may metamorphose into a charge sheet, they would have to be tested in the normal course. She left it at that. Judge Skippers then categorized 3 crisp charges. When the charge sheet is prepared, he is slapped with 6 counts. I will not talk about those other counts because they are not before us. They were abandoned. But what is common cause is that the original charge sheet, which is now an exhibit before you, listed 6 counts. No explanation was given. We nevertheless welcomed it. My client pleaded not guilty to all those 3 charges, which broadly paraphrased relate to the following. 1, the metric charge. I will call it that for ease of reference. 2, the gross misconduct charge that relates to Ms. Suli Mutsweni, how he unlawfully appointed her to a particular position and how he unlawfully gave her 1.5 million. The 3rd and final charge is the Persian charge. I'm using that language because that is the diction that is used in the public protector's report, that is used in all the courts that preceded this hearing. And incidentally, one of the employer's witnesses used the same language. But for us legally trained people, it is the charge that relates to him having unfairly dismissed 6 employees. We plead not guilty, and we put the employer to the proof of its case. In an attempt to discharge the onus and the evidentiary burden that rests on his shoulder, the employer called 3 witnesses. We now know who they are because they've been unmasked. Jabulani Mabaso. Now, let's deal with the testimony of Jabulani Mabaso for what it is worth. And you will see, Mr. Chairman, in my document, I spent a bit of time on his testimony compared to what my colleague does. But the high watermark of what he says is the following. He is employed as an executive of human resources, group executive human resources. He joined the SABC on the 23rd of June 2013. He says, I'm the custodian of all HR processes and everything, compliance. One of the first things that I had to do when I got to the SABC was to look at the personnel records because they were generally in a state of shambles. Nothing peculiar to Mr. Mutsweni. Generally. He says even the PwC, a reputable firm, had to be commissioned to look into the personnel records because they were just in shambles. I'm highlighting this because something was sought to be made about the fact that, but Mr. Mutsweni's personal file had 1 page missing, as if there is some shenanigans underway. I'm using the testimony of the employer's witness when he says the SABC's personnel records were in shambles. And it is one of the first things that he had to do alongside PwC. He was then led about the processes, the policies that are normally to be followed when vacancies arise. He basically says you can either advertise internally or externally. You can use a hybrid situation where you do both. But they would always lean favorably towards internal candidates. In the absence of a policy, he says in some instances, they are guided by what he regards as best practice or what is standard industry norm. He gets asked whether or not he knew about the circumstances pertaining to Mr. Motsoeneng's appointment back in 1995 or his re-employment in 2008. He says, no, I was not there, I was never involved, I'm unable to offer any assistance beyond that. Did you ever see Mr. Motsoeneng's matric certificate? That is how the question was framed. He said, no, but it has nothing to do with me. Do you have any knowledge how Ms. Suli Motsoeneng was appointed and how a salary came about? He said, no, I was not involved in it. However, what I do know from an HR perspective is that, firstly, there would be nothing wrong if preference is given to internal candidates. We know he said that in general, without referring to anyone in particular. The charge that he was being called upon to testify on was the fact that Mr. Motsoeneng supposedly appointed Suli Motsoeneng illegally and paid her an illegal amount that he dreamt up in his head. He says, normally a manager would motivate for that particular person's increase in scope, but then HR would then grade the added responsibility to determine the grade. The grade determines the commensurate pay. That was that. Beyond that, he didn't have any knowledge. He was then confronted with a document that purported to be a contract of employment between the SABC and Ms. Suli Motsoeneng. He was asked to look at the front page to confirm the contracting parties. He was directed to the last page to confirm the signatories. You would remember he said, signed acting COO George Claudi Motsoeneng and then Suli Motsoeneng. That was it. The post, monitoring and evaluation, which is the substantive post that is the subject matter of charge number 2. And the cross-examination, I pointed it out to him to say, look at the documents again. Before I could even finish my question to him, you'll remember, Chair, he said, I'm not sure, there seems to be something not kosher with the documents. I asked him to look at the documents in the order that I suggested. And I pointed out to him that what he read on the first page, and what he read on the last page is not in relation to one composite document. He considered. The first few pages dealt with the substantive position of head monitoring, compliance, and operations, at the end of which there were 3 signatures as opposed to 2. The one that he read with 2 signatures pertained to a different substantive post, which is actually a promotion higher than the previous one. He considered that we are now talking of 2 separate and distinct documents, even though my colleague put it to him as if it is one composite document. In his explanation of why is it that in the one agreement there were 3 signatories as opposed to the usual contracting parties, he actually had something very telling to say. He said, I might not have been there, but I can understand this is Motsoeneng's signature, this is the employee's signature, and Thabiso Lesala acting GM HR. He says, I can only opine that the reason why Mr. Lesala would have signed as a GM HR, it is because HR is a custodian of all labor-related and HR policies, so it is not surprising for him that Mr. Lesala would have signed. In fact, that would give further integrity to the fact that as HR, we have satisfied ourselves that all the applicable processes and prescripts were followed. Otherwise, there would be no reason why Mr. Lesala would append his signature on that document if it is not other than to assent to the correctness of the processes that were followed. Incidentally, that is the very same charge that he is standing accused of, having jipped the processes and appointed his friend or whatever they may attribute their relationship to be, and having paid him or paid her some 1.5 million because it is catchy. He further said, in respect of the second application document, even their 2 processes were followed, or he had no reason to suggest that they were not, because he was not involved in that process. And that was it. That was the sum total of his testimony. Now, at best, he would have testified in relation to count 1 and count 2. count one, his testimony was, I never saw Mr. Mutwening's matric certificate. That is what he was asked. But there was a problem with SABC personnel files. In count two, he says, I cannot tell you how Suli Mutweni was appointed, but there would be nothing wrong in leaning favorably towards internal candidates. Suli Mutweni is common cause, he was an internal candidate. But besides, that particular conclusion of that contract that my colleague showed to him as an exhibit was further amplified by a GM of HR, who is the custodian of HR processes. In fact, I even put it to him that the Lesala that signed, Mr. Lesala who signed, is your predecessor. He says yes, because he's occupying the same position. He said absolutely nothing about the paging. Nothing was put to him, neither did he offer anything. That takes care of the GM's testimony. It does not go higher than that on HR issues. Lorraine Francois is called. She testified for just under 5 minutes, both in chief and cross. She was led ostensibly on her title. She says she is the chief audit executive. Her duties include, but are not limited to, the provision of assurance around effectiveness of SABC's business policies, procedures, compliance, and forensic-related matters. She then went to town to explain how she gets an investigation underway. She said there are different triggering mechanisms. One is contained in the audit charter. One could be in terms of a whistleblowing policy, or the other one would be in terms of a hotline where people phone and choose to remain anonymous. Nothing turned on that because those were the policies and they are what they purport to be. The closest she came to testifying about Mr. Mutweni was when she said she was aware that there was an investigation that was undertaken by someone other than herself. And she was also asked to look at the document. I objected because the document that was being put to her was the one that was authored by this witness that we now know would have been available on the 11th of January 2016.
Exhibit F.
Exhibit F. Beyond that, she herself had not undertaken any investigation pertaining to Mr. Mutweni. She had not herself authored any report that she could have handed in. And that was the high watermark of her testimony. Off she went. Montelari Puko comes next. And you will see in her testimony, the closest she came would have been to suggest that there may have been something about Mr. Mutweni, but nothing. Nothing about count 2, nothing about count 3. I got excited when she started introducing herself and the title Chief Executive Audit. I thought, here fireworks are coming. Muntlenyani Dipoko. Muntlenyani Dipoko was ostensibly called to testify to the paging charge. Charge number 3. You know, I have never been so impressed by a witness of the employer, because his entire testimony confirmed that indeed there was a charade of paging. But most importantly, he had this to say. Actually, of the 6 people that are alleged in count 3 to have been paged or unfairly dismissed by Mr. Mutweni, let me break it down. He said, myself, Munkani Dipuku, Me Mapule Mlabati, Ntswaki Ramaphosa, those 3 were paged. And we were paged by Phil Molefe, whose nickname is not Hlaudi Mutweni. And he took it further and said, the other 3 that make up the 6, Bernard Kom, Hosea Gianni, we were paged as a result of their machinations. He says, Bernard Koma was the initiator. The same Bernard Koma that testified here was the initiator in what he regarded as their paging. Hosea Gianni, the second on the list of 6, that are alleged to have been purged by Mr. Mutweni was the chairman of those proceedings. The third person, Sello Thulo, was a witness. He goes so far as to say, and I will give you that reference, Chair, as soon as I receive the, and there was also a Dr. Pelle, Saul Pelle. He says, at some point the chairman had to go back to Phil Molefe to say, Chief, what do I do with this one? Sort of asking for a mandate to get rid of them. Now, I asked him to read the charge sheet, which he was reading for the first time, and he said it is funny that we are categorized as having been purged by one person, but when in actual fact we are a faction. He didn't use that word, it's my paraphrasing. The first three were our purgers, the last three were the purgees. And all that happened under the hand of Mr. Phil Molefe. That is what he said consistently. He never said anything about Suli Mutwene's appointment, count 2. He never said anything about count 1. He testified about how his employment relationship was terminated at the SABC. Because I realized that he clearly knew nothing about this charge, I then took him through to the report of the public protector. I make that point, Chair. In page 15, paragraph 31 of my heads. And I'm not going to take you through, other than to say, for the record and for the sake of the media, I read directly from the report of the public protector, where the public protector, in express terms, put Mr. Mutweneng's involvement in different categories, direct involvement and there's indirect involvement. In relation to Mr. Montlanyane Dipuko, who is a witness of the employer, Mr. Montlanyane Dipuko says, firstly, I read out that excerpt of the public protector's report. And he said, you know, this thing is becoming a problem because I've heard rumors that I am alleged to have been purged by Mr. Mutweneng, and that is contained in the public protector's report, which I've never really read. And I said to him, let me be the first gentleman to read it out to you and show it to you. And I read paragraph 10.5.2.1 under the heading direct involvement at page 140, and it was repeated at paragraph 10.5.2.7 at page 141 of the self-same public protector's report. He expressed outrage at that. I asked him, what did you say when you met the public protector? He said, sir, I've never met the public protector. I was never invited by the public protector. I was never part of the group that may have gone to the public protector. I asked him further, but sir, what he said about you is that not only was your termination of employment at the SABC as a result of some indirect, banana type arrangement, it is under direct involvement. And he said, that aggrieves me. I am still aggrieved by that because I never spoke to the public protector. If I had been invited or if I had spoken to her, I would have told her exactly what I'm telling you now. As a matter of fact, I am one of the people who were right. It is true I was purged, but I was purged by Phil Molefe. As a matter of fact, at that material time, Claude Mutweneng was not in any position to dismiss me or to influence that I be dismissed. He was even in Bloemfontein. Our relationship remains cordial to date. That is what he said on record. It is unfortunate that it was at the time when the media was kicked out, at the instance of the same employer that charged us. But be that as it may, we now know what he said. He also indicated that he himself, Mapula Mlabati, and Ms. Ramaphosa, their termination of employment was at the instance of Phil Molefe. They had absolutely zero to do, zero, nada, with Mr. Mutweneng. He recalls being invited by one Sello Tulo to say there was a group that wanted to go see the public protector about other issues. And he said, I'm not part of you because I don't have an issue. Because it was clear that the narrative was about Motsoeneng then, and he did not have an issue with Mr. Motsoeneng. And that was the end of his testimony. And remember, Chair, he had not said anything about counts 1 and 2. The next star witness was Mr. COO, who also wanted to testify in camera. We objected because it's no longer an employee of the SABC. And you ruled rightly, Chair, that the media must stay, but the cameras must not face him. He too could not say anything about count 2, so that we leave it out of the way. He testified to a limited extent about count 1, the metric issue. The sum total of his evidence was when he joined the SABC, he joined the SABC in 1991 as a broadcaster, 1981, in the then Radio Setswana under the auspice of Radio Bantu. That is what derogatively, under apartheid, that's how we were referred to, until he left in 1991. He performed various functions ranging from broadcaster, translator, producer, and a commentator. When he applied, because he was applying for a broadcaster position, the minimum requirements then was a teacher's diploma. So when he applied, he submitted his matric certificate and a teacher's diploma. He was not there when Mr. Motsoeneng was appointed, even though he preceded Mr. Motsoeneng in terms of appointment within the SABC. But he was not party to how Mr. Motsoeneng was appointed. He can't offer any commentary on what preceded his appointment. However, he was shown a document, Exhibit E, by my learned friend, to solicit his response. He naturally read the first page, it's Motsoeneng, his biographical information. Second page, he was directed to the bold inscription that is written, Matric Outstanding. And I asked him in cross-examination, what in your understanding means outstanding? He said it means it's not there. He then went to say in...
Mr. Majava, perhaps I should also ask you, please address towards me, then I can hear you.
Oh, sorry, Chair. He then also said it in Sesotho. He said Haiyo, and the Chair interjected, Haiyo meaning Haiko, Haiyo, it's not there. He said yes, went on further to say it in Setswana, said, Haisi initeng, meaning it is not yet there, which means that it could not have given anyone an impression that it is available, only not on hand. I asked him to look at the subjects on the left of the inscription on the second page, let's call it that. And I also asked him, as an educator, as a teacher, as a person who is in possession of a matric yourself, how many subjects back in the day did you require to obtain a matric certificate? He said between 6 minimum and 7 subjects. I asked him to count how many subjects were stated in the form that we've just read from. He said 5. Would that have satisfied the minimum requirements for him? He says no, there is no way. Unless you are an exceptional genius, maybe 5 subjects could have done it. And I asked him, but you can see the symbols that are put in there are not those of a genius. It's EE, Fs, and whatever he considered. That was his high watermark about that document, bearing in mind that he bore no personal knowledge about it. He was not there when it was concluded. He didn't know the circumstances. And that was the objective commentary he could give on that documentation. He specifically said that he is not in a position to gainsay what those who were there when he was employed had to say. The bulk of his testimony related to how he felt aggrieved by an accusation that he procured Mercedes-Benz through a Debbie's contract without following proper procedures. He explained in great detail how he tried to explain himself and how he was let down. Throughout his testimony, he mentioned the name of Mr. Motsoeneng twice, which is the passages that I referred to when I addressed my colleague's submission. He said Mr. Motsoeneng called him and said, I'm sitting with about 9 or 10 colleagues here around the table. There are these allegations about this contract. Please explain yourself.
You better speak the truth.
Come again, Chair?
Something to those words, like you better speak the truth.
Yes, you better speak the truth. No, in Sesotho said, don't die alone. No, tell the truth. And I'm indebted to the chair. That is exactly what he said Mr. Motsoeneng said to him. And he also said Mr. Motsoeneng did not hide the fact that he's sitting with about 9 other colleagues when he made the call to him, inviting him to speak the truth or to explain himself. He said he explained himself. He thought that his explanation was accepted. On the next occasion, he heard Mr. Motsoeneng addressing a press conference wherein he said a manager has been fingered in relation to this contract and disciplinary proceedings would be taken against that person. Those were the only 2 instances where he referred to Mr. Motsoeneng, either in relation to his abuse of power or having engineered his dismissal. The rest of his testimony was very clear that he felt hard done by his immediate seniors, none of which were Mr. Motsoeneng. In the end, he explained that on or about the 18th of November 2011, he receives a call from another employee of the SABC, which is not Mr. Motsoeneng, who informs him to say, you need to collect a parcel from our messenger. He arranges, he goes with his son, they meet this messenger. True to form, in the parcel is a disciplinary notice or a charge sheet with a notice of a disciplinary action. That charge sheet, he says, in his own mouth, was not signed by Mr. Motsoeneng. On the 21st of November, 3 days later, he decided for personal reasons to resign. Wrote a letter of resignation. He had just lost his mother and there were other personal factors that made him feel that enough is enough. It means there is reality. The reality is sinking. And he voluntarily left the employ of the SABC. Later, he consulted with his legal representatives. He may well have been advised to report the matter to the CCMA, which he did. During the CCMA proceedings, before the matter could be finalized, a settlement was reached between himself and the SABC, which resulted in that settlement being made a CCMA award. I was at pains to stop him from disclosing the terms of the settlement because I felt the point had been made that he left voluntarily. However, he went to the CCMA alleging constructive dismissal, and in the end, the matter was settled between the 2 parties. So it does not matter what the terms were. He volunteered that he received 900,000. That 900,000 is now finished now, Chairman. I'm broke. I don't have it. I don't have medical aid. I don't have pension fund. This year, I was planning on retiring when I turned 60 on the 16th of December. That is what irked him the most. He also indicated that at one point he was sitting with his wife watching TV, and his wife said, hey, they're talking about you there in the news. Who? Filmulefe. For whatever reasons. Said what he had to say. Are you sure it was not? He says, no. Cloud is not Phil. This man had nothing to do with that. Cut a long story short, he settles, he takes the money, they part ways with the SABC. The question then becomes, but why then did you go to the public protector? And this is what he had to say. He said, I went there because I wanted personal satisfaction. Because I felt hard done by. I was even avoided by the people that I trusted. I sent numerous emails. And he put a question to me. And I told him that one day he'll sit here, he'll ask questions, I'll answer, but he must answer questions. But the point of what he was saying was simply this. Somebody must tell me if I did anything wrong by writing emails, by resigning, by going to the CCMA, because I still feel that I've been unfairly accused. So I went to the public protector to try and get some closure. I specifically asked him, because I regarded him as a material witness for the employer, what exactly did you say to the public protector? Because when I read the charge sheet, it says you were directly dismissed by Mr. Mutweni. The public protector contains the same narrative. He says, no, I spoke about constructive dismissal. We debated what constructive dismissal means, and there's a labor practitioner himself, because he, on occasion, acted as an initiator, in some cases acted as a chairman of the DC of the same employer. So he knew what constructive dismissal meant. And he disputed flatly that he never said anything to the public protector about him being dismissed directly by Mr. Mutweni. Directly asked by my learned friend about the abuse, I'm not going to go there because I dealt with it in my prelude. But the sum total is that he said there was nothing untoward in their relationship. They remained collegial to date. He disavowed any suggestion, simply put, that he may have been forced out of the SABC by Mr. Mutweni or directly unfairly dismissed, as is in the wording of count 3. That was the high water mark of Mr. Bernard Goma's testimony. Enter Paul Tati. Mr. Paul Tati testified that he too was an HR practitioner of the SABC, having joined the SABC in 1996. He concedes that he was not present when Mr. Mutweni was employed. He arrived a year later. However, he was told by Mariswane Poole and Helena Botes that there was an outstanding issue with Matric. And he said that he asked Mr. Mutweni about his Matric, and that he never found that Matric certificate in the file. He met with his colleagues to bring him up to speed. He was also shown Exhibit E. He gave his own interpretation. In fact, he said, this document alone is conclusive proof that he's guilty of misrepresentation. Because you can't, next to higher standard passed, write 10, and the symbols say something else. And it was pointed out to him that that's exactly the point. If you need 9 courses, well, I needed 10 courses to get a junior degree. When I apply for a job, I can't say I've got a BA or an LLB which required 10 courses and I write 8 courses or 9 courses. Because the two versions are mutually destructive. Because you know for a degree you need 10, you put in 9. In this instance, on the very same form, one line underneath, there were 5 subjects which he considered were in any event not enough for a matric certificate. Yes, he spoke about the outstanding inscription, but he was adamant that this document alone is conclusive enough. That is as far as he could take that issue, the matric issue. He did not give any testimony with regard to the Suli Mutweni issue. He also did not give any testimony with regard to the paging. But what is important about this witness, that before he could start testifying, you'll remember, Chair, he qualified his testimony by stating that he has a contract with the SABC. It's been running for 2 years. He's supposed to go for a 3rd year. Now that contract is being questioned. He has reason to believe that there is an attempt to intimidate him. And I see the Citizen also ran with that story as if it was the only thing that transpired yesterday. He said he believes that there is an attempt to silence him or to intimidate him. And if that is the case, then the SABC has its work cut out, because it will strengthen his resolve, is the language he used. The same SABC on whose behalf and on whose favor I'm supposed to testify is attempting to silence me. In cross-examination, I said with him, I'm a colleague, I'm a decent colleague, Nohal. Are you attributing any of this to my client, so that I don't waste too much time cross-examining on stuff that is unrelated to my client? To which he responded in the negative. He said, well, I'm not saying it is him, but it is just a coincidence, and coincidences are coincidences, something flowery like that. We then left it. the bulk of his testimony was on his interpretation on form Exhibit E and what he thinks it is. Interesting, Chair, and you will note that, Chair, I've gone relatively quickly. I'm on or about page 25. At the end of his evidence in chief, I collegially asked him, I see you've been shown documents, you've taken the liberty of expressing opinions. Is there anything that might have skipped your mind? Any document that you might have forgotten? He remembered a letter, one letter. As I was laying a basis of the letter, he indicated that that is the letter that he wrote to Mr. Motsoeneng demanding his matric certificate. When he perused his letter of March 1996, the 27th of March 1996, he then quickly realized that the language contained in that letter is not supportive of the theory that he was postulating. Because in there, the letter said, may I borrow it for a second? No, this one, J and K. May I also borrow K? Thank you. I made him read the letter, made him identify it. He smiled, yeah, that's my letter. Then I made him read the content of the letter in the light of what he had testified to in chief. When he read the letter, he realized that in the letter, he had this to say. We refer to the conversation between yourself and the writer, and this letter was addressed to Mr. Motsoeneng on 19 March 1996 in the above regard, and confirm that you, Motsoeneng, have undertaken to write the outstanding cost towards obtaining your matric certificate during October 1996. We also confirm that it was pointed out to you that the lack of this certificate will be a serious impediment in your career progression in the corporation. We wish you every success in your academic endeavors and advise that we will follow your progress with interest. Now, clearly, on a literal reading of this document, he was not saying, hey, bring that matric certificate. He says, go and write the outstanding. Now, which therefore begins to explain why there was that inscription that says matric certificate outstanding, why under the subjects listed, there were only 5 subjects as opposed to 6 subjects, which is the minimum requirement. It was at that point that he then said, no, actually, I had the first discussion with him. He insisted that he had a matric certificate. I had a second discussion with him. He insisted that he had a matric certificate. It was only on the 3rd occasion that he confessed that he didn't have it. And when confronted with that letter, he realized that he is in problem land. I leave that inference to the chair. The second document that was handed to him, which was also put to him, is Exhibit K. It is his letter dated 5th June 2000. He had forgotten about it. In that letter, he had this to say, and it is a letter that he had written to Mr. G. Motsoeneng, TV Newsroom, Broadcast Center, Bloemfontein. Dear Mr. Motsoeneng, I have pleasure in advising that with effect from 1 June 2000, you will be appointed as specialist producer. From this date, your annual salary will increase to 111,216 rands. Your salary code and other conditions of employment will remain unchanged. I trust this appointment will show that the goals you have set for yourself are achievable through dedication and hard work. I look forward to your continued high level of performance and wish you every success in the future. This appointment is subject to 6 minutes probation. Yours faithfully, signed, Paul Tati, Human Resource Manager, News. At the bottom, I, the undersigned, accept the amendments to my contract of employment subject to the above terms and conditions. Copy of this letter is returned herewith. It's signed by Mr. Motsoeneng on the 6th of June 2000. Then the pulse of Africa's creative spirit. He identified this document. However, he indicated that he knew the proceedings that preceded to the issuing of this letter. However, the signature there is not his. And in fact, the chairman pointed out that there appears to be a PP. The issue regarding the signature was not canvassed beyond that because he said it's not his signature. Mr. Mutwening's instruction was that I have no way of knowing whether it's his or not. All we know is that the letter was given to Mr. Mutwening by him. And that was the other document. The question to him was then, obviously, if there were these issues about his outstanding matric certificate, how is it then that you appoint him and you appoint him to a much more senior position? He started earning 20 or so thousand rands per annum. He's now at 111,000. We submit, Chair, that barring the issue of the signature, he did not disavow the fact that there was this appointment made, other than saying that he didn't want to have anything to do with it, and he does know that indeed Mr. Mutwening did take up that position. And to be fair, we did not, with any enthusiasm, assert for a fact that that is his signature, but he did not disavow the content of the letter and the ensuing employment. That then was the sum total of Mr. Tati's testimony. Largely, it centered around count 1. Nothing was said about count 2. Nothing was said about count 3. At that point, the employer then closed his case. We immediately entered the employee's case by calling one witness and one witness alone, Mr. Alvain Kloppers, whose testimony I will not go into in any great measure of detail. Safe to say, Mr. Kloppers, one, joined the SABC in 1977 and he is still with the SABC to date. He never left the employ of the SABC. Everybody knew that he is still within the employ of the SABC. I jokingly put it to him whether did he at some point immigrate to Australia. He said no, he's always been around. He heard through the media and the grapevine that there were these allegations about Mr. Mutwening, and he was surprised that nobody bothered to even ask him. I asked him to briefly explain the circumstances around which he met Mr. Mutwening. He also, by the way, mentioned that he was never invited by the public protector, in spite of the fact that he was made to file an affidavit by the SABC in 2012, in which he recorded his entire testimony, which he confirmed when he testified viva voce here before you, Chair. He said he met Mr. Mutwening in 1993 at the steps of a government building at a function in the Bantu stand for TK Mupedi then. This young, talented black man said to him, "Are you from the SABC?" He answered in the affirmative and said, "I'm looking for permanent employment." He said, fine. He gave him his card. That was it. At that time, the SABC itself was already using Mr. Mutwening's material as a stringer/stroke freelance journalist, filing for the SABC in Bloemfontein, filing from Kwakwa. He was also doing material for Makumani and this other morning show for the SABC. And he said they paid him for it. In 1995, in the new dispensation, to use his language, he says, Chair, we were now almost changing the SABC from being a state broadcaster to a public broadcaster. And there was a transformation agenda that the board of the SABC had decided should be driven vigorously. He was responsible for the eastern part of the Free State. He had a discussion with Gavin Reddy in Bloemfontein, and he said they were battling to find Sesotho announcers. And he said, Reddy, it can't be because I told you some time back that there was a young, talented fellow there who was already in the system, whose material you were using, and you were paying him for it. So it can't be true that you can't find these people. Please make use of this person. He then had a discussion with Mr. Mutwening. Within the first 60 seconds of his discussion with Mr. Mutwening told him, "Sir, I don't have matric, and I'm not sure if that is a problem." He said, no. It was at his insistence that Mr. Mutwening was eventually employed. The only person who offered resistance was a young Olivier in Bloemfontein, all these other managers who embraced the transformation agenda, saw the vision, had no difficulty. It took a senior executive from Johannesburg to fly down to Bloemfontein to tell Mr. Jan Olivier that this appointment will happen. And it did happen. With the full knowledge of Mr. Motsoeneng's matric situation. As a matter of fact, he testified that the SABC itself took him to a Thompson Foundation journalism course, which he completed in February, and was only appointed on the 1st of March, having completed that course, which the SABC paid for. The long and short of what he said was, there is no way that the SABC, his employer, that is now charging him today of having lied to it, can in all seriousness assert that. I put it to him whether or not that would be nonsense for the SABC to say what they say in count one. He answered in the affirmative. He went so far as saying, Chair, he is aggrieved. Is it because he, as a white man, offered an opportunity to a black talented young man? He says he believed that he did the right thing, and he stands by what he did. Even if Mr. Motsoeneng was now a big man on the 37th floor, he was even scared to go up there. But he did not harbor any vindictiveness. He felt vindicated by the appointment that he made. He was then confronted with the same Exhibit E and asked to render commentary. And he indicated that it is confusing. If it was done in his office, it would have been done differently. And Marie Swanepoel, at whose instance that was done, had no authority whatsoever. She was indeed a sedentiary clerk. There was nothing she could do to overturn that decision that had already been taken in Johannesburg. All she had to do was to fill in the forms and make sure that the bank, accounts, and all these administrative things that normally go in a personnel file are done. That is what he said. He was also honest. He said, I cannot tell you who completed this form because I was not there. I was in Johannesburg. This was done in Bloemfontein. However, he made the point, Chair, that if he had been involved or if he oversaw the signing of that shoddy workmanship, we would not be sitting in this mess that we are today. Most importantly, Chair, he also indicated that in 2012 still, he had occasion to address a press conference flanked by, amongst others, the chairman of the SABC board then, Dr. Ngubane. He handed you Exhibit I, we skipped IQ, which was basically a clip and online publications. It also bore a photograph of him addressing that media conference. And that very night, that issue was canvassed in the news bulletins. So there was no way that anybody could have harbored any impression that the SABC can now all of a sudden come back and claim that it was misled. Because the narrative in the charge sheet says, had Mr. Motsoeneng not lied about this matric, he would not have been employed. But the person who employed him says, it's absolute nonsense. We employed him with the full knowledge. It caused so much drama that a big executive had to fly from Bloemfontein to deal with Jan Olivier, who was resistant to this transformation agenda. So it cannot be for the SABC now to come back and say it was lied to. Because he says he was directly influential in his appointment. He drove it to the point of overcoming all forms of resistance. He also said that he knows that at some point Mr. Motsoeneng's employment with the SABC was terminated, and he came back. It is a matter of public record and it's common cause. Witnesses, in fact, Mr. Tat in particular, was shown a certificate of service from the SABC pertaining to Mr. Motsoeneng. It was a certificate of 5 years good service that was given to him in 2013. My Bantu education arithmetic tells me that if that employment history was not interrupted, we will be talking of at least 15 years service, not 5 years service. So when his employment was terminated in 2006, it brought about an end to that employment relationship in any event. So even if it were to be assumed that that employment contract was concluded unlawfully or whatever, it came to an end in 2006. In 2008, he was re-employed in a new category, in a different category. And nowhere in the charge sheet is it alleged that when he was re-employed in 2008, he was asked about the metric and he lied about it or he failed to produce it. Nada said about that. So at best, just on pure legal grounds, even if it were to be said that his employment was tainted, the same cannot be said about his re-employment, which started in 2008. We're talking now 7 years employment, which also tells you that legally there is a new intervening action, which is the form of a new employment contract. But even quite apart from that, it remains our submission, Chair, that there was absolutely nothing to suggest that the first employment contract, i.e. the one that was concluded in 1995, was accompanied by some form of illegality or some form of wrongdoing along the lines suggested in count number 1. We submit, Chair, that that is consistent with what is contained in his first affidavit, the 2012 affidavit. That is what I call it in my head. It is also further consistent with what I say in the second, what he said in the second affidavit. We call it the 2014 affidavit. Now, my learned friend suggested that why didn't Mr. Mutsweni come out publicly and say his side of the story? He has done it on no less than 3 occasions in the form of court papers under oath in affidavits. I don't need to remind my colleague that court papers are public documents. He had done that on 3 occasions. I'm sorry that I deprived you of the opportunity to hear the juicy details by him electing not to testify, but he was under no legal duty to do so. We will stand or fall by that election, which the chairman will make a determination on. But it is incorrect to say that he's been quiet all along. He has been quiet in the public domain on my advice, which advice he accepted. I said, let them have their time, your day will come. And indeed, his day came. And when it came, we starved his detractors of hearing from him. Because we thought, and we submit, Chair, it is better that those who employed him tell you the circumstances. It is a lot more weightier, we submit, that you hear from that honest Afrikaner gentleman. He had nothing to gain by lying for Mr. Mutsweni. In fact, he is standing by a decision that he took in 1995. He believed in the transformation agenda. He fought all forms of resistance to make sure that talent is identified. And actually, in some twist form of fate, he has been vindicated because the man went all the way from a trainee journalist to the second in command of a public broadcaster, not even a state broadcaster. But having said that, Chair, there is nothing in the testimony of Mr. Kloppers we submit that has an iota of untruthfulness in it. When it came to the question of whether or not Mr. Mutsweni, in relation to Exhibit E, had any motive, he says it's absolute nonsense. He had no motive. Why would he lie in order to get a job that he has already been given with the full disclosure of his limitations, if at all that was a limitation? Most importantly, he says, to date, sitting in that chair, I'm still not even sure if that was ever a legal impediment to him being appointed. He says, take into account the social, political considerations at the time. They don't make them that honest anymore, Chair. Even under cross-examination, he actually emerged stronger and stronger to a point where his temperature was now getting to a boiling point because he was irritated by the suggestion that Mr. Mutsweni lied. He said, I quote, Mutsweni is not a liar. He did not lie to me. I did not lie to the SABC. It was put to him again by my colleague to say, where in the charge sheet is reference made of your personal private conversation? Because the impression was created that the discussion that he had with and about Mr. Motsoeneng were private. In re-examination, Chair, you'll remember, and members of the media laughed. I asked him this: Mr. Kloppers, is the SABC a human being? He said, no, it acts through human beings. So when you had discussions about Mr. Motsoeneng, were you doing so on behalf of yourself or on behalf of the SABC? The answer was on behalf of the SABC. When you discuss it with other colleagues, including the GM that ensured that he was employed, were you on a frolic of your own? The answer was in the negative. And nothing came out of the cross-examination. I'm therefore asking, Chair, that you take his testimony, unassailable as it was, read it in conjunction with the first affidavit, as well as the second affidavit. It completes the picture in relation to count number 1. Nothing. He did not lie to get a job. He didn't lie to anybody. He was upfront about it. So says an employee of the SABC who directly employed him, not people who came ex post facto and are now expert analysts on a document. This is a warm body that was responsible from the beginning to the end. In conclusion, Chair, you are obviously going to have to ask yourself one question. Why did Mr. Motsoeneng elect not to testify? The simple answer is this. It remains our considered opinion that he had no case to meet. The evidence led by the employer did not meet the minimum threshold required in the discharge of its owners. Put differently, it did not meet muster, and there was therefore no need to place him on his own defense. But what we did do in the employee's case, we led evidence. The strongest possible direct evidence that was ever led in these proceedings. And it was from a witness who happened to have been independent, an Afrikaner for that matter, whom one would have expected to be resistant to transformation, but he embraced it and he proactively pursued it. He spotted talent and he was proven right. It can never, by any stroke of imagination, be suggested that Mr. Kloppers testified in favor of Mr. Motsoeneng for any other undue means. No such suggestion was even made in cross-examination. And I'm asking you, when you weigh the cumulative evidence, place more and stronger emphasis and attach stronger and heavier weight on his testimony, because it is as direct as it comes. No one has gainsaid what he said. Of the 5 employers' witnesses, no one was around and no one could even suggest that whatever he said or he may say was incorrect or could be doubted in any manner whatsoever. Mr. Kloppers did not even have to touch on any other counts. His purpose was to testify in respect of count 1 because nobody had advanced the employer's case in respect of count 2 and count 3 in any significant degree. It is with that in mind that we made an election to close our case after having led a direct witness. We therefore conclude, Chair, that you must return a verdict of not guilty on all 3 charges that were preferred against Mr. Motsoeneng. With regard to Exhibit E, I now turn to the last phase of those issues that you said you would also invite me to deal with. There is absolutely no legal basis on which you should admit Exhibit E finally. In spite of your generous indulgences to my colleague, he is constrained to tell you why you should, even in its incomplete form, with a signature missing, with no plausible explanation. You are not even told what steps were taken in an endeavor to locate the original, the due diligence test. It is not good enough to say, from where I am, from the bar, I don't know, I'm told we don't know what happened to it. It's simply not good enough. If the employer's case rests on that document and on that document alone, you would have expected the employer to have been a little bit more proactive, or at the very least file an affidavit or lead evidence of the custodian of such documents in relation to what steps they have taken, so that when you exercise your judicial discretion to either admit or not to admit, or determining what weight to attach to it, you do so informed by the steps, as the best evidence rule would expect us to do. The very first witness that the employer kicked off with told us that he's the custodian of all HR processes, policies, files, and everything. And it was not even put to him to say, realizing that in his personnel file this crucial document or documents were missing, what steps did you do to establish the whereabouts of the original? Did you speak to those who were there before you? Did you go to the archives? That basic objective information was not solicited, and it is therefore not before you. I have sympathy with my colleague that he has difficulty, but unfortunately, they made their bed, they must lie in it. I therefore rest. Can I just take the final instruction?
Just before you go, I just want to know with Exhibit E that you are addressing me now.
Yes.
You will remember there was a lot of cross-examination about that document.
Yes.
And you will also remember that there were different witnesses who identified that document.
Yes.
Now, I would like to hear you on that.
Okay. Perhaps, Chair, let me backtrack. I am very cautious in addressing you on that aspect because I can see where the rationale is going, which is fair. The fact of the matter is, to the extent that you had admitted it provisionally, we had to cross-examine on it.
Yes, that's the main thing. And what do I do about the evidence on the cross-examination?
Yes. And
either allowing the document or
if
not allowing the document, and also the evidence that contains around that.
Yes, Chair.
I'd like to hear you on that.
Chair, first prize, and I would be silly if I want to have my cake and eat it. First prize is, do not allow the document because it is not properly before you. If you do not allow it, the concomitant evidence that I might have successfully solicited in cross-examination falls away with it. If you allow it, then you'll have to take into account that which was obtained as a result thereof. I'm constrained. I'm not a
Perhaps I should bring it closer to the point.
Yes.
You will remember that Mr. Tati identified it, Mr. Koma identified it, and so did Lopez.
Yes.
The witnesses of the employer never mentioned any problem with the document except one page missing.
Indeed. Not
Mr.
only
Lopez had a different view on that document.
Yes.
You remember?
Yes. In fact, let me deal with the first
and
proposition.
that's why I'm asking you that.
Yes. Let me deal with the first proposition. They identified it for what it purports to be.
And I recognize it from the original document. I got the impression.
No, it was only Mr. Tati who said.
I'm referring to him.
Yes. He said he remembers that in its original form, there was a page missing.
But it was signed.
That is what he said.
Yes.
And then I asked him, in its original form, how many pages was it?
Yes.
And he
There was a mistake about whatever the pages were.
They were not a mistake because he didn't realize that the document that he had was printed back to back.
Correct.
Which therefore meant that if he was correct in his assertion that it was a 4-page document, he was wrong. Because it would have been a 5-page document if there was another page missing.
Yes.
However, I do accept that he said, for what it is worth, there was an additional page missing. But where Mr. Tati's evidence comes short, he also could not confirm that that document follows in chronological order.
Correct.
Yes, and that is the point I'm making. I am not saying to you that he did not identify it. He says, I had a look at it because it was brought to my attention by Helena Botes and Mariswane Poo. But he himself disavowed personal knowledge of that document.
Correct.
the witness that I would have taken this much further with would have been Mariswane Pool, who would have purportedly have been present when the form was filled. It is for that reason that I do not take the point further with Tati, because he simply considered, even in re-examination, he wasn't there, he doesn't know who completed it, he does not know who wrote outstanding, who wrote the biographical information. With Mr. Kloppers, you are right. He made the same observations, but his take was different. His take was that it was sloppy HR work. That's the first thing. Because he said he spoke to the HR in Johannesburg, who would have conversed with the HR in Bloemfontein. And they always knew what the position was. But he considered that I'm constrained to tell you what is it that they did wrong. All I know is that I could have done it differently to remove away any doubt. We would not even be sitting here. Because he said it was very, very clear that Mr. Motsoeneng did not have a matric. He never held himself out to hold a matric. And therefore, the way the inscription is on Exhibit E is problematic. And hence, it lends itself to different interpretations. And he considered that he cannot say for sure what happened because he was not there. So he identified it in that context. In fact, Chair, Mr. Palani went a step further and asked him if it is similar to the one that he signed in 1977.
Exactly why I'm asking you that question.
And he said he can't even remember. The point of the matter is the authenticity of the document still remains an issue that should bother you. I submit with respect, you do not have anything to say to you conclusively. This is a complete document, let alone the fact that it is a photocopy, uncertified photocopy. You don't even know if it is a complete copy of the original.
You see, Mr. Majabu, with regards to this and the silence of Mr. Motsoeneng,
yes,
I find myself now in the position that there's a lot of cross-examination on their document. There's a lot of explanations of hoo-ha in the zoo, if you may call it that.
Yes.
But I don't have any clarity on those specific situations. I'm not saying that you should have asked him to come and explain it.
Yes.
I'm merely saying that I'm sitting in the situation where Mr. Palani has presented the documents provisionally before me, the different versions of what everybody takes from that document.
Yes.
And the point is, I see there's a Swanepoel who signed it. Marie Swanepoel, apparently.
Yes.
She was not called, for reasons I don't know. But be that as it may, the point is, what is the evidential value, and should I allow it in the end? If not, because of people who have identified their document as being the one they had seen in the past. You understand my question?
Except in that none of those ever said that it is Motsoeneng who completed and signed it.
Wasn't he the best person to come and tell me?
Yes, Chair, provided that evidence was led to suggest that he had signed it. He would have been. That is a fundamental point. You are right. You are on to a very valid point.
That's why I'm asking you.
Yes, and I'm saying that is one of the considerations that we took into account. None of the witnesses said it is he who completed the document. All the witness said it contains his biographical information at best. Because he did not disavow it, therefore it must be his. If Marie Swanepoel had been called to testify, I can assure you, Chair, I would have put Mr. Motsoeneng to his defense. Because Marie Swanepoel would have been the direct evidence in relation to the form. She would have even been the person to explain what became of the original. Is this form what it was from a recollection back in 1995? Because then there would be something, prima facie, that Mr. Motsoeneng on the form would have had to come and testify to. That is as far as I can take the point. And I'm saying, Chair, this is precisely the point to say you were not even told that there was an intention to call Marie Swanepoel for that matter. Now, and the employer knew that its case centered around the form and the person who may have been present when the form was completed, in the form of Marie Swanepoel. There was not even an attempt to say to you, Chair, we request a postponement because we need to get hold of Marie Swanepoel. She's out in Cape Town or wherever, or we'll ask the DA to help us locate her because they successfully located her previously. None of that was put before you. You were told repeatedly that there is this witness that we want LCG Oosthuizen. And I'm trying to demonstrate the point that what worries you is indeed exactly the point. It is not, we submit, the responsibility of Mr. Motsoeneng to come and close the gaps in the employer's case. in instances where nothing of sufficient value has been put before you to warrant that he must suffer the consequences of the election that he makes. In the end, Chair, you are going to make that cumulative weighing of the evidence before and make a decision. And I do concede that I stand or fall by the election that we made. And I take cognizance of the point that you've raised. However, I strongly assert that the most distinguishing feature here is that none of those said for a fact that it is his form, he signed it. Had that evidence been led, it would have been a different point altogether. And in all probability, and I'm not speculating, we would not have made the election that we did.
Okay, thank you, Mr. Majava. The last point I want to hear is Exhibit F.
Yes. Can the Chair refresh my... I'll take this.
That's one of Elsa Westhuizen, which I have not read. I've received it provisionally. I have not taken cognizance of the document.
Similarly, Chair...
but it was allowed, I think it's in my bundle here. Here it is.
Chair, what is even worse about this document is that it is unsigned.
I have not looked, Mr.
Yes, I'm saying to the extent...
I want to know what is the value of that document.
There is absolutely no value whatsoever. Firstly, you should not allow it. If you are minded to allow it, you should attach little or no value to it. It is not even signed by the person who is supposedly the author hereof. And we know we've had an incident where there was at least a signature next to Mr. Tati's name, and he disavowed that signature. This is worse. It is blank. There's no signature. Unless if my colleague has a signed version and for some reason you and I have an unsigned version.
But irrespective of that, Mr.
I'm
Mujabo,
saying,
the point is I allowed it provisionally on the basis that it would be qualified.
And the qualification has not happened.
I'm asking you to address me on that. What do you want me to find on that?
I am asking you to find that you cannot allow it permanently because firstly the qualification that was the basis for its provisional admission has not happened. And that is also consistent with your ruling, your earlier ruling.
Thank you. Is there anything else, Mr. Majabo?
Let me just take instructions. Chair, I'm indebted to my associate on that very point, who has also indicated an SCA decision that seems to be authority on how you could deal with secondary evidence. It is a footnote number 8 in a judgment of the SCA. I just want to get you the neutral citation is Transnet Limited versus Newlin Investment, Pty Ltd, 2011, square brackets, ZASCA 44. It was handed down on the 29th of March 2011. When you do look at it, and I will send it electronically, both you, Chair, and my colleague, paragraph 3 thereof has this to say: there are no degrees of secondary evidence, and although production of a photocopy would be more reliable than oral evidence, and failure to produce a photocopy may be cause for comment, this goes to weight and not to admissibility. And in paragraph 19, it deals with the two requirements. if it be accepted that the original had been lost by the appellant, then the second rule of evidence, which I shall now deal with, becomes applicable anyway. On secondary evidence, once secondary evidence is admissible, there are no degrees of secondary evidence. That is, common law no longer requires that the best secondary evidence has to be produced. And then it quotes Phipson at footnote 8, which has this to say, I quote, "The general rule is that there are no degrees in secondary evidence and that a party is at liberty, subject to comment if more satisfactory proof is withheld, to adduce any admissible description he may choose. The reason assigned is the inconvenience of requiring evidence to be strictly marshaled according to weight and of compelling a party before tendering inferior evidence to account for the absence, all of which is superior value, but the very existence of which he may have no means of ascertaining." Now, at best, Chair, we submit, the first submission is that you should not admit it, in which case we don't have to worry about the weight to attach to it. But in the event where you have to admit it, we submit that the weight to be attached should be reduced significantly. And you have to look at objective factors that were put before you in so dealing with it.
I'm indebted to you. Thank you, Mr. Mayor.
And I will send the full judgment. My colleague just handed it to me.
Thank you very much.
May I just take an instruction
Yes.
from client? Thank you, Chair. Those are our submissions, unless the Chair would like me to canvass any other issue that might have
I'm
eluded.
satisfied. Thank you, Mr. Mapwangu. Mr. Palani,
Chair,
have you anything in reply on what we've heard from Mr. Mapwangu?
I have a reply, Chair.
Then please proceed.
I will be dealing with charge number 3.
Number 3.
Yes.
Yes.
I would submit that the impression that has been created that only Mundenyani Dipuku on charge number 3 was fired by Mr. Musweni is not correct. There are other names such as Bernard Koma and Sulutulo. The only person that said I was not dismissed by Mr. Musweni was Mundenyani Dipuku. In that way, the evidence of Bernard Koma that he was, I must state it categorically. I don't want this to be quoted out of. The evidence of Mr. Bernard Koma that prior to even him being disciplined, Mr. Musweni contacted him saying without even having been charged, will support the charge. And that was never disputed.
I understood what you said, but yes. Perhaps you should do the translation. Because perhaps there's other people who don't understand.
Sure, you understand South Sudan. I must place it on record that we communicate in South Sudan.
I understood what you said.
Okay, but I will make it. I will make meaning that I will fire you. Yes. It stands, and it was never disputed.
But perhaps on that point, let me ask you this.
Yes.
Because it's important what you will say.
Yes.
You will remember that Mr. Koma testified
yes.
that he was chairing or either the initiator with disciplinary hearings at the SABC. Many of them.
Yes. In fact, thousands.
And he was specifically asked were they all convicted or not.
Yes.
And he said many were acquitted. Remember? Now, it obviously sometimes happens that someone says, I'm going to fire you, and then gets acquitted at the DC. It doesn't mean that I'm going to fire you, that you are going to get fired at the DC. Obviously that also happens. But can we say that here? Because Mr. Koma didn't attend that DC. We will never know what would have happened. I understand where you're coming from, but somehow he voluntarily resigned. And are you submitting to me that he was definitely going to be fired, as Motswaneng told him? Or are you saying it was possible, or don't we know?
I would say that that saying that I will fire you had an impact in him being charged.
Well, we know that he was.
Yes.
He actually received the charge, not a
Yes.
disciplinary hearing.
Yes.
He actually received the charge or the indictment from the messenger, remember. But be that as it may, perhaps it was a situation that Mr. Goma had to be fired, because we don't know what he did. He denies he did anything wrong, but perhaps if Mr. Motsoneng said that it was the correct thing to do, you understand what my problem is?
Chair, I would say that.
Let's accept,
yes.
just for argumentative sake, let's accept Mr. Goma was involved in the Mercedes-Benz purchase for 45 odd million or 20 million, the figures were, I think if I remember correctly. Let's say he was involved in that unlawfully. What do you think would have happened to him? You understand my problem? I don't know whether it was correct or not correct, and you can't tell me. The point is, if a senior manager tells someone you are going to be fired when it has done a grossly unfair or unreliable thing, do you say that means it's purging or not?
Chair, I do understand where you're going.
This is why I'm asking you.
But I'm going to answer by saying that if you look at the charge, how it is written, it says you directly initiated the dismissal or termination of the POGO. Termination. By virtue of resigning, I understand they went to the CCMA for maybe that.
Are we talking about Goma or the POGO?
Goma.
Yeah.
Yes. Maybe I would say that there was it can be a constructive dismissal, if I can put it that way.
Well, we don't know. It was never adjudicated. So, you see. Now, I'm merely asking you on Mr. Goma. You said the reason why I should accept it is because Mr. Motsoneng told him, if I accept that it's the correct facts, let's accept it for a moment on argument, that you did tell him that. My question to you is, so what? How does it prove the charge?
Chair, if you are told,
If I tell someone I'm going to fire him, is that purging?
and the following day he's charged,
Well, what is, if he gets convicted, that sounds different. But you have to look at the evidence.
no, the words that were supposed to maybe to be used in that conversation was to say, I will charge you, not I will dismiss you. Dismissing it means it was already conclusive. Even that hearing that Mr. Goma was going to attend.
I'm merely deliberating the situation.
Yes, I'm just trying to bring it to your attention, Chair, that the word I will dismiss you and I will charge you are different. If you say I will dismiss you, it means even if you attend the hearing, the purpose of that hearing really, you're already dismissed. You will be dismissed. That is what it means. I wouldn't attend that hearing even if it was myself. There's already a conclusion that I will be dismissed.
Perhaps if you had a good lawyer there, you would have a good chance. But anyway, that's just the informal.
Yes.
I follow. If you've got anything, I interrupted you actually. So
Yes. I just wanted to say that even Bernard Goma on this count is there. And
But just on that point, Mr. Bernard Goma said there are a few things. He got told he was going to get fired. He wrote email. There was a conversation, as Mr. Manjabu said, 2 conversations with him and Mr. Motsoneng, where he called him in front of many other people, 9 or 10 or whatever they were. Are you saying those 9 are also in the same boat as the charge?
Chair, I will submit that. I cannot per se and for sure answer the structure of the SABC and
You
what
know
was
why
the
you
thing.
can't tell me, sir? Because we don't have those things. That's my problem that I have. You understand? We don't know. And it's not for me to speculate. I must evaluate the different versions here and get to a factual finding and then evaluate it. You understand? And I'm merely asking you to assist me to get to that point. You understand?
I do.
So you are saying to me the fact that if I accept Motsoneng had said that, That's posing. I should convict him just because he said that.
Yes, that is my view. He should be convicted. Exactly.
Right?
And then I will come to the issue of Mr. Tati's testimony vis-a-vis the document submitted. I would say that Mr. Tati's direct evidence is to the effect that he demanded the matric certificate. Without that form or whatsoever, we have got evidence from Mr. Tati saying he demanded the matric certificate. And Mr. Mutwening considered that he indeed have matric certificate. He will bring it after 1 week or so.
That's on the basis if I accept it as correct.
Yes. And 1 week lapses to be resigned. I can put it that way.
Let me ask you this. Can you remember why Mr. Tati left the SABC? Is evidence on that? Do you remember or don't you?
I have to refresh my mind. Yes.
Doesn't matter. You will remember that he had an introduction with his testimony when he started.
Yes.
Did you were leading him on that? Correct? Or did he do it by himself? That he was disappointed with allegations of him being involved in perhaps some
No,
dishonest
that one I
conduct.
must say he did it by himself.
But no, I'm not asking you to testify.
Yes.
I'm just asking you, Mr. Majova had a long argument on that issue. Perhaps if I read between the lines that there were some undertones that he was disappointed and he might have a motivation or a motive, is the argument of Mr. Majova that I should carefully consider. And I'd like to hear your take on that. Now that you now tell me you didn't lead him on that, makes it worse, but let's not go there. I won't take that into consideration. The fact is he said it.
He said
What
it.
is your take on that?
But I cannot see how he will have a motive on
You see, there's an issue being made by Mr. Majavu that Homa is heartbroken for various reasons that he's argued. And he says it seems that Mr. Tati is also disappointed. These are the two gentlemen you are relying on for conviction.
Yes, I will dismiss those views, both of them. Must be dismissed. They are not true. And I can, for instance, say that Mr. Koma testified honestly, even the manner in which he was testifying, I couldn't see any ulterior motives. He was saying the facts he know, how they happened. The facts were chronologically stated to the extent that my colleague didn't challenge his evidence. Second to Mr. Tati, perfect witness. I don't know what I can say. If I had an order to give, I will give him a national order, maybe of Mapungu, of some sort. Perfect witness. He had no motive. The letters he have written happened way back when he was still at the employ of the SABC.
All right, then last question that I have for you on Mr. Tati.
Yes.
You remember he wrote him that letter in 95, the one he acknowledged he signed. He was the author of that.
Yes.
And he put him on terms for Mr. Motswane.
Yes.
Is that correct?
That is correct.
Yet 5 years later, nothing's happened. Why would that be? I'm inviting you to convince me why that is something I have to consider.
If my memory serves me very well, Chair, Mr. Tati testified that he had options.
He had to go somewhere else.
He had
some other operations that he had to do.
No, he had options either to charge Mr. Mutwening, but he allowed him.
Yes. That was initially in 95. He felt sorry for him.
Yes.
That's
That is his evidence.
He gave him an opportunity.
He gave him an opportunity,
Yes.
and so far, even to date, nothing happened.
No.
No.
You're sidestepping my question. The question
yes.
is, Mr. Tati did say that he was going to assist him and he felt sorry for him.
Yes.
And gave him opportunity to qualify.
Yes.
Yet 5 years later, it seems there was The DC in between that, Mr. Poma doesn't know why he stopped. He was the initiator. And Mr. Tati can't tell me why he actually, after he put him on terms, had ensued that. What should I make of that? That's what I'm asking.
I would say that the conclusion that the chair must make, it must be out of fact. And inference, I can use that word, that should be drawn from those facts, is that he was given an opportunity. And then after he didn't complete, then the SABC deemed it fit to charge him.
What are the probabilities on this compared to what Mr. Kloppers was saying?
Mr. Kloppers, in the first place, I would say that is not working at the...
No, I'm not asking you where he's working or whatever.
Yes.
On the balance of probabilities, we have Mr. Tati and Mr. Poma's versions.
Yes.
Nothing ensued from these putting him on terms and giving him an opportunity, or there's a DC on his matric certificate which he's initiated and stopped, doesn't know why, compared to what Mr. Kloppers is saying. He was actually the man who recruited him. And all that goes along with whatever his evidence is, whether it's correct, if I accept it as correct. How do we, isn't that then probable that whatever Mr. Klopper said was correct? Because this is why the DC didn't go ahead, or why Tati didn't discipline. Or must I infer something different? That's what I'm inviting you to ask to answer.
Chair, I would submit that the charge that he is facing is in relation to the form.
Talking about charge 1?
Yes. To the charge in relation to count 1. That happened in 1 March 1995. Yes.
All right. I've given you my problem.
Yes.
Can you address me on that now? Was that your answer that you're giving?
My answer is that whether he was charged or not, that doesn't dismiss misrepresentation he has made.
But
It
what
stands.
is your charge? Is that he didn't have an email directed to the SABC at the time that he had one?
He had one, yes.
Now I'm asking you on the different versions, on the balance of probabilities.
On balance of probability, you have Mr. Kloppers that says that he knew that Mr. Mutsening doesn't have a matric certificate. 1. 2, you will have the SABC 1 year or so later after the employment demanding the matric certificate. It doesn't balance. The SABC, it has a lot of employees that are learned. I do not think they can make an error of knowing that the man doesn't have a matric certificate, demand it. If they knew he didn't have, under different leadership of different people, if they knew he didn't have, they wouldn't demand it. There are so many people, I can give an example, that works without matric certificate. But it is never demanded because they disclosed that we do not have a matric certificate. Common sense will tell you can only demand what you think it is there.
If the left hand knows what the right hand is doing, that I accept, yes.
Yes, you can only
But
demand.
it seems there was disarray there, Mr. Chabulani Mabasu tells me. But anyway, I hear what you say. Is there anything else?
Let me just go through. Yeah, the other thing is that during a re-examination of during testimony of Mr. Kloppers, the letters of promotions and everything that happened after, I want to address you because I know it is important. The fact that he was promoted later doesn't cure the defect of misrepresentation. I must put it very clear.
I accept that.
He's not charged. The charge is not relating
If
to
I accept that you this misconduct, then you are correct, yes.
Yes.
I accept that, yes.
Just see if I've got
The fact that he did something initially wrong doesn't make it good later because he's promoted. I accept it. That's correct. But
Chair.
then it must be that it was indeed misconduct.
Yes.
Or fraud, or whatever you want to call it. Because it goes with some criminal matters also to me.
Yes, those criminal matters had, I must indicate, had the same standard as the labor law that I quoted. In criminal law, I must put it here very clear. In criminal law, in labor law, and in civil, where there are facts before you, evidence is presented that is against you. The case that is we have got a very, very strong case, I must say. Under these circumstances, where we have got this strong, very, very strong case, I will submit that in all sphere of the law, if you don't testify, an adverse inference should be drawn. That is why I was quoting even criminal cases to say.
It's criminal law, I understand what you're saying.
Yes.
Criminal law is another onus.
That is why I even quoted the labor law by the Honorable Justice Murphy.
Your onus is easier than the criminal. But I accept what you're saying.
Yes, even where it is beyond reasonable doubt. You should come and
But you also understand that it's a new case law on the criminal law that the reasonable court must be able to convict after the state's case. Which is not, you are saying that I should have convicted Mr. Motsweneng after your case. Because
yes.
He should have actually come and explained.
If he doesn't come and put his version while there's a strong case to answer, he should be convicted right away.
All right. Okay, so now I follow what you were saying.
Yes.
Is there anything else?
Nothing else.
Thank you, sir. Mr. Majabu, you are finished. I just need you to, there's two or three exhibits that were used yesterday with Mr. Kloppers that I would like to get back. I have not received them back because I'm now going to sit down and prepare my
Chair, just arising, just a small point. You questioned my colleague on the language used in charge 3.
Yeah.
I just want to make one small point to say it is noteworthy that in charge 3, the language used there is unfair dismissal. That is directly attributed to Mr. Motsweneng in relation of 6 employees. Of the 6 employees, only 2 testified for the employer. It's Koma and Munkenani Dipu. And he says both of them were good witnesses. If they were good witnesses, I will invite you, Chair, to then look at the transcript and accept what they say in relation to the allegation, specifically in count 3 about Mr. Motsweneng. That is why I took the trouble of quoting from the transcript, so that sight is not lost of that. And you will also ask yourself why, if the man is accused of having 6 people, only 2 are led, and those 2 on our version exonerate him. That is all, Chair. We rest and we will await your ruling, Chair. Thanks for the indulgence.
Thank you very much. I will now go and prepare my judgment and give it my ruling as soon as I possibly can. I indicated yesterday that I will do it tomorrow morning, 12 o'clock. If I'm ready earlier, I'll let you know. But it won't be before 11 o'clock. Between 11 and 12, I will come and sit and give my rebuttal judgment. Obviously, I won't have time to type it as I sit until that time to formulate.
Even us typing this.
But I might get the PA here to type it, but that's a joke.
Yeah.
So that's fine.
So, Chair, we must be around here between 11 and 12.
Yes,
Unless
let's make it, as I said, 12 o'clock.
Okay.
If there's a problem, I will let you know, as I did today, because I thought you would tell the people what they follow. But be that as it may,
Thank you, Chair.
I will give my rebuttal judgment tomorrow at 12.
Thank you, Chair.
Thanks. Let's check it there.
Oh, okay. What you told me not to apply.
I need E. correct it, yeah. The application.
And remember, we never had it. You know what I'm saying is, yes. Finally, that's pin. Reconstruct and keep. When you go down?
This man now drives.
Mr. Palani. Your gentleman, eh?
Yes.
Your friend. Can you just have you got the clipper?
No.
It had a clipper on it.
Just absent the transcript.
Okay, thanks.
Whatever. Just check whether my colleague left it and sent it on my behalf.
I'll take some. Get it on I know where it is. Yeah. You clipped it.
You had a nice note.
You do it the whole time.
Enjoy it.
No, I get a little change.
I thought you had a sister. Not so.
That was very funny.
Mr. Madam, did you check for me? I want to sleep tight tonight, huh? Knowing that you want to transfer. I'm going to go from
No, it's fine. I'll check. There's only one person who's not sleeping tonight. The one who's going to do the right thing. I'm going to have a dog. Dan, I didn't sleep last night. Thank you very much, sir.
Did my best. No charges, ne? Okay, Mr. Majab, you can't charge me.
No.
Okay. Never ever. Sharp. You know what? They didn't clip them together, so some are going in, some are going out. Sure. Do this, Mr. Chair. I'm going to have
Relatively.
HIV virus, yeah. Must not develop my computer.
That one is not infected.
Were you holding back? Okay? Were you holding back?
Why is it not ready? It must. Give me the thing. Okay, that's see, now this software.
Assist you as well for me. Thank you so much.
Let's see.
Yes, yeah. I was trying to keep busy so I don't fall asleep, you know. At 1.1 was just falling asleep. How do judges start the judgments?
How do they do what?
How do they start the judgments? They always say they're
So it's a
indebted.
matter of so and so and so.
No, they always say that they're indebted to people. I hope I'll see my name there.
I did that for the whole of South Africa.
Oh yes.
And I knew you would appreciate that.
What is it? SUS.
You got that one.
No, which one? The last part.
Yes.
Wow.
Yes, you got it.
No, I didn't. What was I doing?
I was talking about you.
Oh, no, I didn't get it. Not even. Yeah. Okay, are you going to need today's one?
No,
Or
that's
you
just the
fine?
arguments.
Let's close it.
Yeah, if it comes, you can have it. When it doesn't, this is great.
Oh, okay. All right. I think we should have supper or something.
But you leave first now.
Yeah.
I'm not sleeping good.
Okay.
Or I'll get up very early. Either is it my gone.
Gone.
Sweet. Friday.
So you did what you had to do.
Someone at least one. They're not making like register party in seconds.
So tomorrow they
Just
can.
Now.
Up until arguments.
For now,
So,
Not yet, that's true.
for now,
Oh, hey, they're very nice. Must just get nice.
arguments when you're doing it.
I don't have to do this.
How long does it take?
How many pages do you know?
Did you ever find it?
How many pages?
Yeah, it's going to be around 20. How much?
But they, it was
Why are you talking to me more?
Thank you so much, Mr. Chair.
Mr. Chair?
We are very glad. My boss said I must tell you she's the biggest fan. She's like, that man is my hero.
Really?
Yes.
Can I tell you something?
She's the head of ER.
Can I tell you something else? While we were watching outside on TV, there were guys that came from the Free State, and they all knew. And they were like, saying, I know you from Nampop. I know you from somewhere else. And I said, wow.
He's famous. Huh?
That's nice to hear.
It's very nice to hear. So this was nothing. It wasn't making you famous. You're famous already. It was just confirming what they already knew.
I think it's more famous like Josh Massey, basically.
there wasn't anyone who said, that don't kill them conflict. At least there was no one who said
Nothing saying that.
I wanted to say to you.
No,
Yes.
you can't leave.
No. I'm leaving. Let me tell
Before you
you.
go.
I wanted to say to you, I love your pretty accent.
Oh.
Over the last 4, it's very, it takes me back home. Every time you speak English, it's just so genuine. Oh, this is Pedi, come late.
of our